Before the court drawn near, the Honorable Judge Cedric Simpson presiding.
And good morning, everyone. Court does call the case of Dexter Shops LLC versus Whiskey and Rose Tanning Studio.
Good morning, Your Honor. David Waldo appearing on behalf of Dexter Shops LLC.
I don't have anyone signed in for the tenant.
You have nobody signed in for the tenant. I do have before me a stipulation and conditional dismissal.
That's correct.
And both sides are represented by counsel, correct?
That's correct, Your Honor.
All right, very good. Then what I will do is I will sign off on that. I will enter that. And
Thank you.
you're all set?
You have a great weekend.
You do the same, sir.
Thank you, Judge.
Does call the case of DJM Land Company versus Mitchell Kish.
Good morning, Your Honor. For the record, Stuart Collis, P4953 on behalf of the plaintiff. I saw Mr. Kish's.
I think I do. Mr. Kish?
Good morning, Your Honor. Mitchell Kish here.
Good morning. All right. And what is plaintiff's claim in this case, including cost?
Your Honor, including costs, that would be $6,477.40.
All right. And sir, how are you intending on getting this paid if you believe that it's owed?
I've made a partial payment. They've received a check. They should be in possession of for a partial payment for it, which should be leaving me a balance near $5,800. And I should have that paid within about 7 days next week on Friday.
Well, you're entitled to an adjournment on this, so I will adjourn this matter out. You think that you're going to have the balance paid by then?
Yes, yeah, I do.
All right, I will adjourn this to May 30th, 2025 at
1 p.m.
At 1 p.m. That is an in-person proceeding. If it's not all taken care of.
Sounds good. Thank
Thank
you.
you, Your Honor.
All right. Thank you. Court calls the case of Avalon Housing versus Yolanda Shepard.
Morning, Your Honor. Jillian Engen for plaintiff.
Good morning, Your Honor. Andrew Campbell, P64391 on behalf of Yolanda Shepard. Last night, Your Honor, I filed several pleadings, Judge. The matter is a little bit complicated, and I'm not sure if you would, if opposing counsel will be better to describe what's going on.
Your Honor, it's my understanding that there was a flood in the unit. And so I think that the parties are attempting to resolve this. However, my client needs to go in and complete repairs. And so we're trying to coordinate retrieval of Ms. Shepard's belongings. We're trying to figure out kind of how to move forward. But my client does need to get into the unit and ensure that, there's not going to be entry by Ms. Shepard. And so we filed the ex parte motion with that intent that it would, that the court would give authority to plaintiff to remove and secure defendant's personal property and then dispose of anything that was damaged that's in the leased premises.
And
May I
what
add?
I'm
sorry.
Go ahead.
Yeah, if I may, Your Honor, just to add to that a little bit. We had a 10-day meeting, Your Honor, and my client was living with a neighbor after this flood. And then May 8th, the county came in and put a tag up and locked everybody out. May 9th, opposing counsel emailed me because the day before I had emailed them asking about the case. And they sent me the pleadings and also the notice to quit and the health hazard. Now, those were served, Your Honor, just so you know, on the same date that these pleadings were filed. So I filed yesterday a motion to dismiss for lack of jurisdiction and a response to the defendant's motion, as well as an answer and affirmative defenses. we are trying to work with
What-
them.
Well,
We're not,
let's deal with the jurisdictional issue. What is your jurisdictional issue?
well, Your Honor, it's my understanding that MCL 600.5714 states a person entitled to possession of premises may, meaning it's permissible to recover possession by summary proceedings after a person holds over premises. So to hold over, you have to be served the notice to quit, the 30, if you send a 30-day notice, you got to send it, give them 30 days to comply, and then file your summons and complaint. Or in this case, they did both a 30-day TOT notice and a health hazard notice, but they sent the health hazard notice on the date of filing. And respectfully, I think that that's violating the law, because you're supposed to give them 7 days to get in. And frankly, that's hard to do so when the county has locked you out. And so the court lacks jurisdiction because the requisite requirements by the statute were not met prior to filing. And I listed all the law in my brief, Your Honor, in my motion. Ypsilanti Housing Commission versus O'Day. Plaintiff's termination notice is improper and void. And also Park Forest versus Smith, a proper termination notice is necessary for the court to have jurisdiction. And while the notice was valid in respects to perhaps the content, although we disagree with the assertions, it was not timely. It was not filed in a timely manner. And so my client never had a chance to kind of abide by the demands of the notice. And additionally, I filed a motion for discovery if the court was not going to grant it, because the fire report indicates, I'm quoting from page 1, incident type sprinkler activation, no fire, unintentional. It also states, quote, there was no fire or smoke in the building, end quote. So my client, she wasn't responsible. Apparently this sprinkler, I haven't been in the apartment because we're locked out, but it's cathedral ceilings. It's way up. My client tells me she can't even reach it with a ladder. So the sprinkler just went off and caused all this water to be ejected. She's been, and Avalon has been assisting. They did offer a hotel, but she couldn't get transportation to the kids for school, so she stayed with a neighbor. Now they're offering a hotel again, which we're grateful for, and we want to take advantage of. But my client is poor and doesn't have a lot of money and needs to be able to get a U-Haul and a storage unit. So she went to Faith in Action and should be hearing from them
Why
today.
Why are we going through all of this? It's the unit is untenable, correct?
Well, that's the conclusions they state. They're stating it's untenable, and I don't know I don't know for sure. I don't see any insurance adjusters reports. I don't see anything. There was an inch of water.
I guess I'm not even clear why we're going through this. Under paragraph 31 of the lease, the landlord wants to enter the premises to secure the premises.
Yes, but there's a couple problems with the order, and the order that they proposed, Your Honor. Let me get specific, and because I've been through this before. I've been down here for 3 months, and I've seen this before. And it says it's further ordered that plaintiff may remove and secure defendant's personal property from the leased premises. And here's the problem language: dispose of any rubbish, trash, waste, and other water damage and or flood damaged items contained in the leased premises. That's a problem, because any maintenance person.
Then why don't you just ask that they can just that your client can look at it? I mean,
Yeah, that's what I did in my motion that I filed.
Don't interrupt me. Why are we going through all of this? They need to get into the premises. They tag the unit. They need to get into premises. Otherwise, more damage is going to occur, both to your client's property as well as to the tenant, to the unit.
Well, I'm
Doesn't
sorry
make any
for
sense to me why we're going through all of this.
I'm sorry for
If the
interrupting.
issue becomes the destruction or the disposal of property, then certainly I think council should be able to arrange that as the property's being removed, your client can be there to try to salvage what property is salvageable.
May I speak, Your Honor?
Go ahead.
I apologize for interrupting the court. Judge, there's a lot of issues in this case. If you look at my motion, my response, the problem we have is we want that, Your Honor. We asked at the 10-day meeting for opposing counsel to contact the county and get the county's schedule when they can come out and open the door for my client. And my client can then go in. Nobody can enter without the county's permission, Judge. Okay? That's what we want. But what we don't want is we don't want some maintenance person looking at the goods and saying, oh, that's water
Well, why
damage.
don't you and council get together, contact the county, and arrange a time to go down?
I agree.
What is so hard? What is so hard about that?
There's nothing hard, Judge. It's not on me to do that, Judge. It's a plaintiff's case. And we had a meeting. And
Council. Your client has property that she may want to salvage. It would seem to me that it would be in your interest to contact plaintiff's counsel, get with the county, figure out a time that the parties can go in there. It's in all parties' interest to do that. Your client, the landlord, everybody's interest to get into the unit, get out those items that your client that are salvageable, allow the landlord to go in, repair what's there so that further damage doesn't occur.
I agree. And that's why we had a 10-day meeting.
All right,
I don't understand why I'm not seeing.
here's what we're gonna do. I'm adjourning this to next week. Between now and next week, I'm gonna order that council get together with the county, arrange a time to go into the premises for inspection of the premises and removal of those items.
Thank you, Your Honor. And so at this time, I just want to clarify, Your Honor, you're not entering the ex parte order as drafted.
I'm not gonna enter that order. I'm gonna enter the order directing the parties to get with the county, to gain entry to the premises. That defendant is to remove those items that she wishes removed.
Thank you.
And then plaintiff is also able to secure the premises and stop any further waste on the premises.
Thank you, Your Honor. Two things briefly, Your Honor. We would like to reserve escrow or preserve escrow from today's date. Also, the case was filed under 657-14 1C 1i after termination of the lease pursuant to a power to terminate provided in the lease or implied by law. Obviously, we can talk about that later. I just want to have that on the record.
Well, that's why I don't see the jurisdictional issue, because I think it's properly filed pursuant to the provision in the lease, but we can argue that at another point. But I'm ordering that, and I'll set this for May 30th, 2025 at 3 p.m. That's in person.
Thank you, Your Honor. Would you like us to submit an order to the court in accordance with?
Please.
In person didn't mean I was supposed to be here. I wasn't even supposed to be here.
Thank you. Glencoe Hills versus Justin Jefferson.
Jillian Engen for plaintiff.
Don't have that checked.
Justin Jefferson. There is no response. And I also should say, is it Unganchuku Nasiki? Nasiki? No response. If you'd raise your right hand, I'll let you proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth? So help you God.
I do.
Go ahead.
Thank you. This is a case for non-payment of rent. Rent to retain possession is $3,494.56. Court costs are $212 for a total of $3,706.56. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days. Do I have this after June 2nd?
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested, writ issue in 10 days. Court calls case Glencoe Hills versus Devonta Jackson and is it like China?
It's LaChina. You can call me China.
Say it again for me.
It's LaChina. You can call me China.
Okay, it's LaChina. Okay, I'm sorry. I didn't know where to break apart the syllables. LaChina Williams.
You got close enough.
Okay. All right. What is the claim in this case?
Your Honor, I have a balance including court costs of $1,818.50.
And LaChina, when are you gonna get that? How are you gonna get that paid?
I can get that paid by the 1st.
By the 1st?
Yes.
Okay, so here's our problem. I can adjourn it out a week, but the 1st, June rent is gonna click in.
Oh, is the 30th okay?
Can you pay it on the 30th?
Yes.
Okay. Here's what we'll do. I'll adjourn this out to May 30th, 2025 at 3 p.m. That's an in-person hearing. So can you get that paid? Can you get that balance paid, say before noon that day?
Yes.
Okay, fantastic. Okay, so if you get it paid before noon, then what likely will happen is that plaintiff will dismiss the case, but you may want to check with them, make sure you got everything paid.
Okay.
Okay?
All right.
All right.
Thank you.
Thank you. You have a great weekend.
You too. Bye-bye.
Court calls the case of Glencoe Hills versus Daniel Worth.
Jillian Engen, plaintiff.
Hello.
Hello, Mr. Worth. Do you have a camera?
Yes.
Okay, I'll need you to turn that on, but while you're doing that, oh, you got it on. Okay, what is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $3,067.63.
All right, Mr. Worth, how are you intending on getting that paid?
I have a payment plan that covers next month rent, but it wouldn't be, my balance would be at 0 by next month of the 30th.
Okay, have you talked that over with your landlord?
Yeah.
Your Honor, I don't know that plaintiff is willing, I don't know if we're willing to do, I don't know if plaintiff is willing to do a COD on this one. I can ask my client.
All right, so here's what I'll do, Mr. Worth. Is there anything you can pay between now and next week?
I could do, what does next week fall on?
The 30th of May.
I could pay 1,500.
1,500 by that day?
Yeah.
Okay, so let's do this. You need to pay 1,500 by the 30th. I want that paid before noon on that date, okay?
Okay.
Then I'm going to adjourn this to May 30th, 2025 at 3 p.m. That's an in-person hearing. And then we'll see where we go from there, okay?
Could you do could you do June 2nd for the first payment?
I cannot.
Okay.
Because if you're not gonna, if you can make the payment, you need to make the payment, sir.
Okay, I'll make the payment. I could make it by June 2nd with that 1,500.
All right. Well, I'll put that in the file, but I'll still need you here then on the 30th
Okay,
at 3 p.m.
Okay, thank you.
You. Glencoe Hills versus Daniel Reynolds.
Jillian Engen for plaintiff.
Here,
Mr. Reynolds?
yes.
Okay, there you are. All right. What is plaintiff's claim in this case?
Your Honor, I have a balance, including court costs of $2,068.70.
All right, Mr. Reynolds, how are you intending on getting that paid?
So approximately $750 I could pay by Wednesday of next week, and most of that today. And then that will leave me with my normal rent for the month of May, which I can make another partial payment on May 30th, but it wouldn't be the full amount of May on May 30th. I'd need approximately a week to 2 weeks to catch that up. And then I know
All right,
I'll be
hold
due
on.
for June.
Hold on a second. You're gonna pay 750 by the 28th. That's next Wednesday.
Yes. And that'll just
All
leave
right.
me with May.
Okay, and then on the 30th, how much did you say you're gonna pay?
I'll be able to pay roughly $600.
Okay, and then $600 on the 30th. I'd like that paid to the landlord before noon.
Sure
Okay,
thing. Yes.
and then I'll adjourn this out to May 30th, 2025, 3 PM. That's in person. So, then we can see where we can go from there, okay?
Your Honor, would it be possible for an alternate viewing? I will be in Chicago on next Friday.
Okay, that's the time that I've set it in person. You could submit a form to the court requesting a Zoom hearing, and then we'll consider that.
Okay, and what is the best way to submit that? Do I go to the court or is there an electronic version I could use?
I can put my email in the chat.
You could, my coordinator will put her email in the chat, and so you can make that request directly there, okay?
All right, thank you.
Thank you. Gulfside Lakes versus Sarah Brown and Jalen Brown.
Jillian Ingram for plaintiff.
Good morning, Your Honor. I'm here.
Good morning. Your name?
Miss Sarah Brown.
You're Sarah Brown. Okay.
Yes.
You got it? Okay. And what is plaintiff's claim?
Your Honor, I have a balance including court costs of $3,473.47.
All right. And ma'am, how are you intending on getting that paid?
That's not the cost that I have. I don't know if they received the $2,400 that I paid last night.
We wouldn't
Okay.
know.
Okay.
You would not have.
That would
So you
make
paid
difference.
$2,400 last night?
Yes.
Okay, so I'm gonna indicate that was the 22nd. You paid that.
Yeah.
And then,
in the
so
evening.
that leaves you about 1,000 and some change. So when were you gonna get the balance paid?
I could pay the balance by either in the evening on the 30th or early morning on the 31st.
Okay. So it looks like there may need to be a COD if you can't get it paid by noon on the 30th is what you're telling me.
I can try. I don't want to make that promise because my money hit
Got
like
it.
different times, if that makes sense. I'm sorry.
No, that makes sense. I got you.
Because sometimes it hit earlier in the day, then it'd be in the evening. It's crazy times. I'm sorry.
Okay. All right. So here's what I'll do.
Okay.
I'll let them try to get their accounting and get your ledger all caught up. I'll adjourn this to May 30th, 2025, 3 PM. That's an in-person hearing. And then we'll try to figure out how we're going to work it out if it's not paid by then.
Okay. Can
All
I
right.
get that? May I get that balance again she has so I can minus the $2,400 from it so I'll know what I owe, if that's okay?
Yep, yes, and I have $3,473.47. You can
Okay.
also contact Melissa.
Okay.
She'll give you
Okay. Yeah. And I'll definitely try to have that paid before 3:00 on the 30th. Thank you, Your Honor.
All right. All right. Thank you.
Uh-huh.
Gulfside Lakes versus Lakia Williams and Karan Williams.
Jillian Ingram for plaintiff.
Hello, Your Honor.
Hello. All right. And Ms. Williams, do you have a camera?
Yes, hold on.
All right. I'll need you to turn on your camera. And what is plaintiff's claim in this case?
I have a balance including court costs of $3,593.26.
All right. Ms. Williams, how are you intending on getting that paid?
So I can have about 593 next week, but I am also in the process of working with Hawk.
Okay. So you're working with Hawk?
Yes, I had an
Do you have
appointment with her
do you have an
yesterday.
appointment with them yet?
Yes, I had one yesterday at around 1
Oh,
p.m.
you did?
Mm-hmm.
Okay. They haven't indicated anything then to you?
No, what was her name? I think Alicia. She said
Okay.
she's working on it.
Okay, so here's what I'll do. I'll adjourn your case out May 30th, 2025, 3 p.m. That's an in-person hearing, and hopefully we can have some news from Hawk. Try to figure it out. I suggest that you make the payment that you're gonna make so that if there's funding there, you'll be below the limit that can get paid, okay?
Yes.
All right. Okay,
Thank you, Your Honor.
thank you.
Pardon me, Judge. Could you ask
Yes.
your administrator to clarify the email address that she put in there? I've sent a question. It's a little confusing. Thank you.
Who's
I've already answered his question.
I think she answered your question, sir.
Thank you.
Gulfside Lakes versus Alicia Sarr.
Jillian Ingham for plaintiff.
She's here. Sarr,
Hello.
hello, there you are.
Hi.
Okay. Hello. What is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $219.14.
$219.14.
Yes, sir.
Okay. All right, Ms. Sarr.
Yes.
When do you think you can get that paid?
So I made a payment arrangement to pay the rest of it tomorrow with the landlord.
Okay. So you're gonna have everything paid. If I adjourn it out a week, everything should be paid.
Yep.
Okay, then let me do that. I'm gonna adjourn this to May 30th, 2025 at 3 p.m. That's in person. But if everything's paid, it's likely they'll dismiss the case and then you don't need to appear.
Oh, no, okay. Thank you.
Okay? All right.
Yep.
Take care. Have a good weekend.
Thank you too.
Court calls the case of Gulfside Lakes versus Erica Hall.
Jillian Ingham for plaintiff.
She's there she is. Hello.
Hello.
And I got it right. So, and you know what? You didn't even say, good job, Judge. You didn't say anything. I got it right. I'm just saying that because I'm proud of me. So, all right.
The win.
All right, Ms.
The
Hall.
win.
All right. How much is owing?
I have a balance including court costs of $2,749.29.
You said 2749?
Yes, sir.
All right. Ms. Hall, how are you intending on getting that paid?
I can have everything paid by the 13th of June, but I know that's pushing it. I can make a payment of $600 by next Friday, and I'm taking out a personal loan, but it takes a few days for that to go through.
To get through.
Yeah.
Okay, so let's do this. Pay the 600 by next week. I'll just put by the 30th, if you can pay that early in the day. And then I'll adjourn it out to May 30th, 2025 at 3 p.m. That'll be in person. And you might want to contact the attorney's office, see if they, since you know that you won't have it paid before the 13th of June, to try to work something out regarding a COD or something to get that in June encompassed. Got it?
Okay.
Okay? All right.
All right.
We'll see you next week. Take care.
All right. Thank you.
Court does call the case of Gulfside Lakes versus Emmett Redwine.
Jillian Ingham for plaintiff.
Hello.
Hello, Mr. Redwine. All right. I'm doing okay. All right. How much is owing?
I have a balance including court costs of $3,009.28.
All right, Mr. Redwine, how are you intending on getting that paid?
I'm gonna pay something Friday. I'm gonna pay something Friday, then I'm gonna pay another 1,600 2 weeks after that. Then
Okay, so how much can you pay by next Friday?
I'm gonna pay $750 Friday. It's Friday.
Okay, so $750 by the 30th. It looks like something's gonna have to be worked out regarding a payment plan or something, if it can be. So then I'll adjourn this out May 30th, 2025 at 3 p.m. That will be in person. And then we can see if we can get it get something worked out. Okay, Mr. Redwine?
Okay. What time?
All right. That's at 3 p.m.
Okay, thank you.
Thank you.
Bye.
Court calls the case of Gulf Side Lakes versus Michelle Goebel and Marlon Goebel.
Jillian Engen for plaintiff.
Good morning. This is Michelle Goebel.
Okay, good morning. All right, how much is owing on this account?
I have a balance including court costs of $1,643.74.
All right, Ms. Goebel, how were you intending on getting that paid?
Yes, I get paid every other Wednesday. So I was planning on doing about 600 on the 28th and then the remaining balance on Wednesday, June 11th, both before noon.
On June 11th,
Yes.
but is that that's going to include your June rent or no?
I think so. Yes, yeah.
All right, so here's what I'm going to do. You said you can pay 600 by the 28th.
Yes, sir.
All right, get that paid. I'm going to adjourn the hearing to May 30th, 2025 at 3 p.m. That's an in-person hearing. And I'd suggest that you contact plaintiff's attorney's office, see if you can work out some type of either conditional order dismissal or something regarding this case, okay?
Perfect. Thank you so much.
All right, thank you. Have a great day.
Again, you too.
Gulf Side Lakes versus Mia Salvano.
Jillian Engen for plaintiff.
I don't have her.
Mia Salvano? No response. You've been sworn. You may proceed.
Thank you, Your Honor. This is the case for non-payment of rent. Rent to retain possession is $2,784.07. Court costs are $172 for a total of $2,956.07. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Can you give me that amount again?
Yep, $2,956.07.
Got it. Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested. Writ to issue in 10 days. Hamilton Crossing 2 versus Tanisha Ballard.
Jillian Engen for plaintiff.
Do not have this bound.
Tanisha Ballard. I do not have her. You may proceed.
Thank you, Your Honor. We're actually looking to do a conditional order of dismissal with this one. I can place terms on the record, and it's going to be submitted to the court.
Okay.
Okay, so defendant may retain possession of the leased premises through the end of the lease term, provided that defendant complies with the following terms. As of May 9th, 2025, defendant has an outstanding arrearage of $2,178, includes $172 in court costs. Plaintiff shall pay the outstanding arrearage as follows. And I realize that some of these dates are before today's date. The payments have already been made in compliance with this. $300 on or before May 10th, 2025, $285 on or before the 10th of each month from June through November, and then $168 on or before December 10th, 2025. And then defendant shall pay monthly rent in the amount of $772 on or before the 25th of each month, commencing May 25th, 2025, and continuing through December 25th, 2025. And then commencing January 1st, 2026, defendant shall pay monthly rent timely. Defendant shall comply with the terms of the lease.
All right. So I see those certainly as more favorable terms than the entry of a judgment in this case. So I'll enter the COD when it's presented with those terms.
Thank you, Your Honor.
Hamilton Crossing 2 versus Joshua Myers. And is it Chairs Myers?
Your Honor, Jillian Engen for plaintiff, forgive me, I switched my order. This is also a conditional order of dismissal. I gave these terms I'm sorry, no, this is right. Okay, I'm sorry. Sorry, Your Honor. Okay, Jillian Engen for plaintiff. Your Honor, we have a conditional order of dismissal for this case as well. I can place terms on the record.
Go ahead.
Thank you. Okay, defendants may retain possession of the leased premises through the end of the lease term, provided that defendants comply with the following terms. As of May 9th, 2025, defendants have an outstanding arrearage of $5,189, which includes $214 court costs. Defendants shall pay the outstanding arrearage as follows: $415 on or before May 10th, 2025, $181 on or before May 25th, 2025, $415 on or before June 10th, 2025, $415 on or before August 10th, 2025, and $260 on or before September 10th, 2025, $415 on or before October 10th, 2025, and continuing with $415 per month on the or before the 10th of each month through April 10th, 2026, $28 on or before May 10th, 2026. And then defendant shall pay monthly rent in the amount of $772 on or before the 25th of each month, commencing May 25th, 2025, and continuing through May 25th, 2026, commencing June 1st, 2026. Defendant shall pay monthly rent timely. Defendant shall comply with the terms of the lease. So,
And I do see those terms as being more favorable than an entry of a judgment by default. So the court will enter the conditional order of dismissal.
thank you.
Court does call the case of Huron Vista Apartments versus Wilbur Burrell.
Jillian Engen for plaintiff.
You're open access. Yes.
Mr. Burrell?
Yes.
Okay, there you are. You're at our access point here.
Hello?
Hello?
Oh, can you hear me?
Yes, I can hear you. Can you
Okay.
hear me, Mr. Burrell?
Yes.
Okay. I don't have a camera on. I'm not sure why that is the case, but what is plaintiff's claim in this case?
Your Honor, I have a balance of $1,525. I also have a note from my client that Mr. Burrell is participating in the Huron Vista forgiveness plan. So I think that we should be putting together a conditional order of dismissal.
Okay. Is that your understanding, Mr. Burrell?
Yes, sir.
All right, so here's what I'm gonna do, sir. I'm going to adjourn your case out to May 30th, next Friday, 2025 at 3 p.m. That's in person, so you'll actually come into the courtroom and hopefully we can have everything worked out.
Okay, yeah, because I talked to the landlord. He told me the terms and the condition to make sure I pay this 3 months and then get help from my SER, from my DHS broker.
I understand the program over there at Huron Vista. So they just have to work out the paperwork and we'll have to enter the paperwork next week, okay?
Okay.
All right, we'll see you then.
Okay, what day you say? Next Friday at 3 o'clock?
At 3 o'clock, yes, sir.
All right, thank you.
Thank you. Court calls the case of Huron Vista versus Alicia Moore.
Jillian Engen for plaintiff.
Alicia Moore?
And just
Okay, hello.
Hello, Judge.
What's your name?
Alicia Moore.
Okay, yes, okay. All right, she's on the phone. All right. What is plaintiff's claim in this case?
I have a balance including court costs of $3,522. I also have a note that Ms. Moore is participating in the Huron Vista forgiveness plan as well.
Okay, so Ms. Moore, what I'll need you to do is I'll need you to come down to the court next week. Hopefully we'll have a conditional order dismissal to enter that regarding the program over there at Huron Vista, okay?
Okay.
So I'm gonna set it for May 30th, 2025 at 3 p.m.
Okay.
All right, we'll see you then. Thank you.
Thank you.
Huron Vista versus Jacqueline Taylor and is it Tania Taylor?
Good morning, Judge Simpson. Good morning, Judge Simpson.
Good morning. And who I'm sorry.
Jacqueline Taylor. This is Jacqueline Taylor.
Okay, gotcha. Okay. All right. What is the claim in this case?
I have a balance including court costs of $2,194.03, and I don't have any notes regarding the forgiveness plan.
All right. Okay, Ms. Taylor, how are you intending on getting that paid?
I'm gonna pay something next week. I had got an email about the forgiveness plan, but I didn't get the letter about it because I fell on the property. That's how I got behind in my rental payments, which I told them. I fell and then I had to take off of work because I hurt my wrist and my knee.
Okay, so, I don't know, is she eligible for the program or you don't know, counsel?
I'm sorry, I'm not sure.
Not sure?
I'm not sure. That would have to, but I will ask.
All right. So Ms. Taylor, have you reached out to the landlord regarding the forgiveness program or not?
I can email today. I will email today when we're done.
Perfect.
Okay, then here's what I'm gonna do. How much do you say you can pay?
500 by the 30th.
Okay, so I'll indicate that you're gonna pay 500. I'll put that by the 30th sometime. I'll adjourn this out to May 30th, 2025 at 3 p.m. That will be in person. Okay?
Okay. Okay.
And then hopefully you'll email them and hopefully we can work something out on that date, all right?
Okay, thank you so much.
All right, thank you. Have a good weekend.
You as well.
Huron Vista versus Rodney Taylor.
I have Jillian Engen for plaintiff.
He's here. Oh, there he is. Mr. Taylor, I'll need a camera, sir. And how much is plaintiff's claim?
I have a balance of $2,223, and Mr. Taylor is participating in the forgiveness plan.
Okay, Mr. Taylor, is that correct?
That's correct. I'm trying to turn my camera on. I can't turn it on. I'm having some problems up here.
Okay, here's what I'm gonna do. Since you're participating in that program, we'll need you here next week, May 30th, 2025, 3 p.m. in person. Let's get the paperwork together and get that all in. Okay, sir?
All right, no problem.
Okay, thank you. Oh, see, you got on just at the last minute. Now I know on the 30th who I'm looking for. Your camera's working. You got it. All right?
Yes, sir.
All
Yes,
right,
sir.
you take care. You have a good weekend.
You too.
Huron Vista versus, is it Charkeisha Roberts?
Jillian Engen for plaintiff.
Charkeisha Roberts, she's not here. You may proceed if you'd like.
Thank you, Your Honor. I am going to take a default judgment. I have rent to retain possession of $2,816. Court costs are $176 for a total of $2,992. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days. And Your Honor, for the record, Ms. Roberts had indicated that she wished to participate in the forgiveness plan. If she does end up, we'll prepare a COD that sets aside the default judgment.
Got it. Okay. Judgment to the plaintiff, that is by default for possession, redemption amount, in the amount requested, writ to issue in 10 days. Huron Vista Apartments versus Moesha Harrison.
Jillian Engen for plaintiff.
Moesha Harrison, not present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $2,230. Court costs are $176 for a total of, of $2,406. Plaintiff is requesting a default judgment with the writ to issue for possession only with the writ to issue after 10 days. And also, if Ms. Harrison does agree to, she has indicated she wants to participate in the forgiveness plan. If I'm sorry, my words are, I haven't had enough coffee today.
We'll set aside the
default
and enter that paperwork.
Thank you.
Okay. Judgment to the plaintiff by default for possession, redemption amount, in the amount requested, writ to issue in 10 days. Huron Vista versus Shinar McGraw.
Jillian Engen for plaintiff.
McGraw, no response.
Thank you, Your Honor. This is a case for non-payment of rent. I have rent to retain possession of $49. Court costs are $176 for a total of $225. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession. Redemption amount, any amount requested with a writ issued in 10 days, no writ without a hearing.
Thank you.
Court does call the case of Huron Vista versus Danielle Davis.
Jillian Ingen for plaintiff.
Danielle Davis. They are not present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $3,346. Court costs of $176 for a total of $3,522. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days. However, if Ms. Davis does agree to enter into the forgiveness program and enters a COD, we will set aside the default in the COD.
All right. Judgment to the plaintiff, that is by default. Possession redemption amount is in the amount requested with a writ issue in 10 days. Evergreen Apartments versus Abraham Hack.
Hello, Your Honor.
Okay. All right, Mr. Hack, he's got his camera on.
Hello.
Right. Hello. All right. How much is owing on this guy?
I have a balance including court costs of $2,823.88. Your Honor, I also do want to note that Mr. Hack has provided a notice to vacate for the end of his lease on June 15th. And so if this case continues till June 15th, we will likely, and Mr. Hack moves out, we will likely end up dismissing.
Is that correct? Is all of that correct, sir?
Yeah, it looks like it's all correct from what I got on the paper.
Okay. Are you gonna be able to make a payment before the 30th?
Yes. I should be getting my last paycheck from my previous job before that.
Do you know how much you can pay by the 30th?
I'm locked out of my Pro that tells me how much I'm gonna be paid on the 30th. So I don't have an actual estimation of how much, but I'm trying to save up as much as I can to pay as much as I can, Your Honor.
Okay, all right. I'll adjourn this out May 30th, 2025, 3 p.m. That's in person. All right?
Okay. Just because I'm a little bit slower, can I just the total cost of what I owe just one more time in person at 3 p.m.
The total amount that they claim is owed is $2,823.80. Was that 88 cents?
88, yes, Your Honor.
And then I was supposed to show up 3 p.m. At what was the address? Is it on the paper that I received at all?
Yes, the court address is 4133 Washington.
4133 Washington.
Right up by the sheriff's department. Okay.
Okay.
All right.
Thank you, Your Honor.
Thank you, sir.
Am I good?
Evergreen Apartments versus Idris Williams. You're all set. Sure.
Jillian Ingen for plaintiff.
And Mohammed Al-Duwasi.
How's it going?
All right. Who is this?
Idris.
William, how you doing, Idris?
How you doing?
I'm doing well. All right. How much is owing on this case?
I have a balance including court costs of $1,989.60.
All right. And Sarah, how is that going to get paid?
Oh, both myself and my brother, we both recently started brand new jobs. I graduated last month. You wish me a happy birthday and a graduation present. I got that all paid up and everything. That previous one paid up. It's just catching up on this 1 month that we're behind now. So I'm literally outside of my job the job. I'm signing paperwork for my new job. Like I was supposed to be here at 9 o'clock. I already went inside and told them I'm going to be a little late. And my brother, he started a new job last week, tiling floors. So he's getting paid a decent amount now, and I'll be getting paid $23 an hour. So it's literally just getting that handled out. We're both still working our other job as well at night at the restaurant in Ann Arbor. So literally it's just trying to get caught up with that 1 month that we are behind. And it was like 1 month and like 200. Yeah.
All
So
right, let's do this. Let's do this before you lose that job that you haven't started yet. I'm gonna adjourn it. I'm gonna adjourn it out to May 30th, 2025 at 3 p.m. All right, that's an in-person hearing. I'm gonna suggest that you contact on your paperwork, you'll see the attorney's office number. Call them and see if you can work something out regarding this back balance. Okay?
Sounds good. Yeah, no, like next month, everything should be cleared up. It's just because like I said, I graduated, the whole situation. So literally it's just trying to play catch up. So I really appreciate it.
Like I said, well, congratulations on the graduation. Get in there, get that job, and let's see if we can get it all worked out by next week. All right,
yeah, I'm
my
using this
friend.
degree to work. All right, have a nice one.
All right, you take care.
You too.
Evergreen Apartments versus Walter Herrera and Daniel Alvarado and Randall Romero.
Jillian Engen for plaintiff.
Any of those individuals present? Herrera, Alvarado, Romero. Nobody's present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $3,611.86. Court costs are $256 for a total of $3,867.86. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue in 10 days. Evergreen Apartments versus Daryl Simpson, no relation.
Jillian Engen for plaintiff.
Daryl Simpson, not here. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $1,592.04. Court costs are $172 for a total of $1,764.04. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Evergreen Apartments versus Denasia Hamilton.
Jillian Engen for plaintiff.
Hamilton?
morning,
Oh, there
Your
she is. Good morning. All right, how much is plaintiff claiming is owed?
I have a balance including court costs of $2,084.66.
All right, Ms. Hamilton, how are you intending on getting that paid?
I contacted my caseworker from DHS. I'm just waiting to hear back. And then I also have some other organizations that I'm waiting to hear back so they can put together and see if they're gonna help pay.
All right. So have you filed for an SER through DHHS?
Yes.
Okay. So what I would need you to do, I'm going to adjourn this case out May 30th, 2025 at 3 p.m. That's in person. There's a form that came with your packet notifying you of this hearing. That's called a rental assistance form. You'll have to file that with the court by next Wednesday and put your tracking number on that form. Okay?
Okay.
Okay, if you can't find that paperwork, you can use the QR code on the screen or you can call our clerk's office and they'll be more than happy to give you a copy.
Okay.
Your Honor.
All right? Yes.
If I may, I have a note from my client that Ms. Hamilton's SER application was denied. I just wondered if she's filed a new one or if she's going to reapply.
Yeah, I filed a new one
Okay.
as of last night.
Okay.
Got it. Okay. All right, so get that information down to the court and then we'll see you next week at 3.
Okay, thank you.
Thank you. Court does call the case of Evergreen Apartments versus Kayla Smith.
Jillian Engen for plaintiff.
Smith? Hello? I think she unmuted. Kayla Smith? Can't hear you, nor can I see you. You'll need to turn on your camera. Not getting a response.
I'll let her know.
Okay. Oh, now there she is. All right, Ms. Smith, can you hear me? Okay, I can't hear you. I can see you now, but I can't hear you. All right, Ms. Smith, do this for me. Can you hear me? Nod your head if you can hear me. All right. Sign off and then sign back in. Okay, and let's see if that'll correct the problem. I'll pass your case. Evergreen Prince versus John Hudson.
Jillian Engen for plaintiff.
Hello?
Hello, Mr. Hudson. How are you, sir?
I'm doing pretty good. Yourself?
I'm okay, I think. All right. Okay, how much is owing on Mr. Hudson's account?
I have a balance including court costs of $1,291.
All right. And Mr. Hudson, how are you intending on getting that paid?
I'm intending on getting that paid by next Friday.
Okay, so you're gonna get the balance paid by the 30th. Can you get that paid before noon on the 30th?
Yes, sir.
All right, so I'm gonna put that here that you're gonna pay the balance. If you get it paid and make sure everything is paid on your account, it's likely they'll dismiss your case. Okay?
Okay, cool.
So, but I'm gonna adjourn it to May 30th, 2025, 3 p.m. If it's not paid, you need to be here in person, okay?
Okay, sounds nice.
All right, take care. Have a good weekend.
All right, you too. Thank you.
Evergreen Apartments versus Nelsa. Is it Nieves Montez?
Yes.
Montanez. I'm sorry.
Jillian Engen for plaintiff.
Hello. Oh, there she is. Okay. All right. And how much is owing on this?
I have a balance including court costs of $3,705.12.
All right. Ma'am, how are you intending on getting this paid?
I told him I was gonna pay some on the first, and then SOS was gonna help me with the rest of it. But first, I have to pay a certain amount on the first.
I'm sorry. Say that again for me.
I told her I was gonna pay a certain amount on the first, and then SOS will help me with the rest because I had to pay a certain balance for SOS to help me with the rest of it.
All right. So you got to get down below the 3,000?
Yes.
Is that what you're looking? Okay, but if that happens on the first, your new rent kicks in, your June rent kicks in.
Yeah, she told me that yesterday.
Okay. So are you gonna try to get everything paid by then? Or
Yes.
all right, let's do this. I'm going to adjourn it out 1 week, the 30th, 2025 at 3 p.m. That's in person. And whatever you can get paid before that date, let's try to get that paid and also try to figure out exactly where Hawk may be or SOS would be with you on this case,
Did you say
okay?
the 30th?
I'm sorry?
Did you say the 30th?
Yes, ma'am.
I don't get paid until the first. That's why I told her the first.
No, I understand that,
Okay.
but we got to try to figure out, you get a 1 week adjournment, but we got to figure out how to do that. And on the first, your June rent clicks in.
All right.
And I have that amount for the record. It's going to be 5,000. The total will be $5,388.17. So we're looking at least $2,388.17 would need to be paid before if Hawk is paying $3,000.
Got it. Yeah. Okay. All right. Thank you, ma'am. We'll see you next week.
See you next week.
Evergreen Apartments versus Keith Johnson.
Jillian Engen for plaintiff.
Keith Johnson, no response. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $3,176.29. Court costs are $172 for a total of $3,348.29. Your Honor, my client has indicated for Mr. Johnson that they would be willing to set aside the judgment if possession or payment is received by the 2nd. And so I'm going to include under further orders that this judgment will be set aside if paid in full on or before June 2nd, or if defendant moves out and turns.
Vacate. All right, very good. All right, thank you. Judgment to the plaintiff by default for possession, redemption amount, in the amount requested, writ issued 10 days. Court calls the case of Evergreen Apartments versus Evelyn Carter, Majesty Moyer, Myron Moyer.
Go ahead, name for plaintiff.
Any of those
I'm
folks?
here.
Okay, and when you say I'm here, who are you?
Evelyn Carter.
Thank you. All right, and how much is owing on her account?
Your Honor, this is a case for termination of tenancy.
Got it.
Tenants provided a notice to vacate that they were going to be vacating function on May 4th, and they have not yet vacated.
Okay, Ms. Carter, what's your position on this?
Okay, so they told me that my lease was over on May 3rd, no, May 4th. So I signed that. I'm thinking I have to move because I got a new voucher, new size voucher. I went to RPI. RPI had already paid May's rent and said my voucher doesn't expire until May 31st. So he told me to stay there until May 31st because I was moving already on June 2nd. I already packed up, already got the DTE scheduled to be disconnected, everything. So that's all I knew. I didn't know what else to do about it because RPI said that they paid them and the voucher is expiring on May 31st. And your lease doesn't terminate until May 31st on our end. So I called Hawk and they just told me to go to court and see what happens with that since I'm already moving, what to do.
Okay. So what day are you going to be out?
Okay, my voucher starts June 1st, but my moving day to my new unit will be on the 3rd of June. So I already have everything scheduled to be turned off for the 6th of June, but if I can get until the 3rd, that'll be fine.
Okay, so here's what I'll do. I won't enter a judgment today, but I'll adjourn this out to May 30th, 2025, 3 p.m. in person, and then we can figure out a move out date and everything else on that. Okay?
Thank you, Your Honor.
Okay, thank you so much.
Thank you. Court recalls the case Evergreen Apartments versus Kayla Smith.
Jillian Engen for plaintiff.
All right. I see you again, Miss Smith. Can you hear me?
I can hear you.
Okay, we can hear you. Now we did it.
Pushed to my phone.
Okay. All right. What is plaintiff's claim in this case?
I have a balance including court costs of $2,902.30.
All right. And how were you going to get that paid?
I applied for SCR and I'm just waiting on a decision for that.
Okay. So how many people are in your house?
2.
2?
Yes, me and my daughter.
Okay. So just so you know, that's only going to net you about $520. Okay. If they approve it.
Okay.
So then we have to figure something else out. So what I'll do is I will adjourn this to May 30th, 2025, 3 p.m. That's in person. And there's a form that you'll need to file called a rental assistance form. You can either get the QR code off our screen, a copy of one came in your packet, or you can come to the court. I'll need to have that filed with the court with your tracking number, your DHS tracking number. You'll need to file that by Wednesday.
Okay.
Okay?
Okay, thank you.
Thank you.
Thank you for calling Language Line Solutions. My name is Carmen, ID number 204643, Spanish interpreter. May I please have your 4-digit access code?
Yes, our number is 1423.
1423. Oh, one moment. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 1423. 14 Thank you. I am ready for your instructions.
Can you please raise your right hand to be sworn?
Yes, one moment. There you go. I'm ready.
Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in the manner now before the court? So help you God.
I swear to the best of my ability, so help me God.
All right, thank you. And good morning, Madam Interpreter.
Good morning, Your Honor.
All right. The court does call the case of Evergreen Apartments versus Lunette Yoder and Jose Contreras.
El tribunal va a ver el caso entre Evergreen Apartments y Lunette Yoder y José Contreras.
Yes, that's right. All right.
Jillian Engen for plaintiff.
Habla Ghislaine para el demandado.
All right. And Ms. Yoder, can you state your name, please?
Señora Yoder, por favor, diga su nombre.
Hola, soy Lunette Yoder.
Hello, my name is Lunette Yoder.
And how much this plaintiff claim is owing in this case?
¿Cuánto se alega que el demandante debe en este caso?
I have a total of $2,775.48.
Aquí dice que son $2,775.48.
Ms. Yoder, how are you intending on getting this paid?
Señora Yoder, ¿cómo usted tiene pensado pagar eso?
He estado tratando de comunicarme con diferentes lugares para que me ayuden a pagarlo, porque ya que soy madre soltera, pues mi recurso ahorita está muy bajas y fue como una situación que traté de ayudar a otra persona. Entonces, pues yo tengo mi otro apartamento y pues yo les había dicho que quisieran pagos, pero no me dejaron la opción. Entonces estoy tratando de pedir ayuda para ayudarme a pagarlo, ya que soy madre soltera y me cuesta mucho recoger esa cantidad de dinero.
Well, I've been trying to see if I can get the money from different places. I am a single mother, and when it comes to my resources, I have little resources. A situation came up where I had to help someone, and I have another apartment, so I had asked if I could make payments, get a payment plan, but they did not allow that. So I'm waiting to see if I can get help since I am a single mother and I just don't have all that money to pay this.
Have you tried to get help through our HAWK program?
Your Honor, for the purpose of accuracy, HOP?
No, it's HAWC.
Thank you, Your Honor. ¿Ha tratado usted conseguir asistencia a través del programa HAWK?
No, nunca lo había escuchado. De hecho, yo no estoy muy al tanto de tantos programas aquí, ya que tengo muy poquito tiempo y no.
No, I never heard of that. As a matter of fact, I just don't, I'm not aware of all the programs that are available here because I haven't been here that long.
Okay. Here's what I'm going to do. I'm going to put you into a breakout room with the interpreter and Amy from the county, our court liaison officer, and she can describe certain programs that might be available to you.
Ok, lo que voy a hacer es voy a sacar un tiempo ahora para que usted le intérprete y Amy del tribunal se comunique con usted ahora aparte de la sala judicial para que ella le pueda dejar a usted saber todos los programas de asistencia que hay disponible.
Ok, excelente, se me parece muy genial y muchísimas gracias.
Excellent. That's genius. Thank you so much for that.
And I will adjourn your case to May 30th, 2025 at 3 p.m. And that's an in-person hearing, so you'll have to come down to the court.
Y voy a aplazar su caso hasta el 30 de mayo del 2025 a las 3 de la tarde. Y para esta audiencia tiene que venir en persona al tribunal.
Ok, y esa información me lo mandan por correo electrónico o directamente a ese apartamento, ya que no vivo ahí, pues no tengo cómo sacar las cosas que me llegan ahí.
So that information, is it going to be provided electronically to me or mailed to the apartments? Because I no longer live there and don't have access to get mail there.
Got it. So you're no longer living at the address, ma'am?
Ya veo. Así que ya usted no vive en esa dirección.
No, de hecho, es que la situación fue así, que una señora que estuvo en calle con sus hijos, yo le di el apartamento a ella para que ellos tuvieran tiempo mientras que yo iba para mi país a ver a mis hijos, porque como yo tengo mis hijos en una situación de migración, yo me fui por unos cuantos meses y cuando regresé, pues todo había un caos aquí con ese apartamento, pero ya yo había movido mis cosas a otro apartamento que ya de hecho, ya yo tenía que desocupar ahora en ese mes que viene, entonces yo tengo mis cosas en otro apartamento y ya que regresé, pues ya yo estoy en este otro apartamento, entonces no estoy ahí.
No, the situation is I try to help this lady that was homeless with her children. So I let her stay in that apartment while I went back to my country because my children are currently going through an immigration process. So I went for a few months back to my country and I left the lady in that apartment. When I came back, I encountered all this chaos going on. But I was in another apartment. And as a matter of fact, I have to move to another, I'll be moving to another apartment this month coming up now. So I no longer live there. I live somewhere else now.
Okay.
Your Honor, can I ask, does Jose Contreras live in the apartment as currently?
Your Honor, may I get a clarification of which apartment?
Yes.
Thank you. Ms. Jillian, may you clarify the question, please? Mhm.
Let me get the address. Ms. Yoder, does Jose Contreras live at the apartment on Woodland Hills?
Señora Yoder, el señor José Contreras vive actualmente en el apartamento en Woodland Hills.
No, él nunca vivió ahí, simplemente a mí me pidieron que alguien estuviera como debajo de mí, lo que sea como para que yo pudiera sacar el apartamento, pero él no tiene que ver nada en esto, digamos, nunca vivió ahí, solamente me hizo el favor de ayudarme.
No, he's never lived there. He just helped me put his name so that I could get into the apartment, but he never lived there. He just helped me to put his name below my name.
Your Honor, if Ms. Yoder would surrender possession and we could place something on the record, I could dismiss as to her and then take a judgment as to Mr. Contreras and as to all other occupants.
Ms. Contreras, or I'm sorry, Ms. Yoder, you have surrendered possession of the unit on Woodland Hills Drive?
Señora Yoder, ¿ya usted entregó posesión de ese apartamento en Woodland Hills Drive?
Hace como un mes yo fui, hablé con ellos, les expliqué la situación y yo fui a entregar las llaves, pero ellos no aceptaron las llaves, me dijo que no lo iban a aceptarlo hasta el 1 de junio.
I went there a month ago and I explained to them the situation. I went to turn in the keys, but they said they could not accept it until the 1st of June.
All right. You will need to go over and turn in your keys because it sounds like you are not going to be living in the premises.
¿Es necesario usted regresar de nuevo allá para entregarle la llave? Porque me parece que usted no piensa vivir en esa localización.
Sí, correcto. De hecho, yo como le expliqué, ya yo traté de hacerlo porque de hecho ya el leasing de ese apartamento ya está para este mes que entra o si no el próximo mes que entra. No estoy muy seguro, tuviera que fijarme en la fecha exacta, pero yo les dije a ellos que no iba a vivir más y de hecho yo quería entregarlo, pero ellos no me lo quieren aceptarlo. Por eso pasó, digamos, por eso estoy en espera.
Yes, I already tried to explain that to them, and I believe the lease on that apartment, I believe it ends either next month or the following month. I have to check the date. But I told them the situation that I was not living there, and I wanted to turn it in, but they did not accept it.
All right. Ms. Yoder, you're giving up your right to reside in that premises. Is that correct?
Señora Yoder, usted está renunciando a su derecho de vivir en esa localización, ¿es cierto?
Correcto, así es.
Yes, correct. That's true.
Okay. Then I will indicate that the defendant one, Ms. Yoder, has surrendered possession. I will grant a default judgment to plaintiff as to defendant two, Mr. Contreras, for possession with a writ to issue in 10 days.
Thank you, Your Honor.
Your Honor, would you repeat that again?
Okay. Defendant one, having surrendered possession, that being Ms. Yoder,
La demandada número 1, la señora Yoder, ha entregado posesión.
I will grant a default judgment in favor of the plaintiff against Mr. Contreras for possession of the unit.
Voy a otorgarle un fallo por incumplimiento a la demandada y por el demandado número 2 tener posesión del apartamento.
With a redemption, with a redemption amount of $2,775.48.
Allow me one moment while I reference a term, please.
Yeah, that's it.
Thank you. Con un importe de rescate por la cantidad de $2,775.48.
If that is not paid, an order of eviction will issue in 10 days.
Si no se paga eso, pues entonces se hará una orden de alojamiento dentro de 10 días.
Thank you, folks.
Gracias. This is the interpreter.
Yes,
Is there anything else I can do for you?
No, ma'am. Thank you very much. Wonderful job. Do appreciate your help.
You're welcome, Your Honor. Thank you for using
I
our
know.
services. You have a good day. Bye-bye.
You do the same. Bye-bye. I am not doing breakout. All right, that ends that block.
Thank you, Your
Thank
Honor.
you. Thank you.
You and your staff have a good weekend.
You do the same. Court
Eventually.
stands in recess.
Okay, district court is now back in session. The Honorable Judge Cedric Simpson presiding.
And good morning. Northfield Estates versus Cheryl Cornett.
Good morning, Your Honor. Rachel Dornbush, appellate law on behalf of the plaintiff.
We have
I'm here.
Cheryl Cornett.
Yes,
Oh, she's
Cheryl
in-
Cornett.
Okay. All right. Thanks, claim this case.
With costs, Your Honor, $1,512.12.
Hey, Ms. Cornett, how are you intending on getting that paid?
I'm not sure. I've had COVID for the last 3 weeks and I'm still not right. I was going to ask if you could give me at least 3 weeks. I have a doctor's note. My other half that lives here with me, he got COVID also. So neither one of us have worked in the last few weeks. So I'm just asking if I could at least get 3 weeks.
Well, you'll have to try to work something out with the plaintiff regarding that. What I will do is I
Okay.
will adjourn this proceeding to see what you can possibly work out. I'll adjourn it to May 30th, 2025 at 2 p.m. That's an in-person hearing, ma'am. So you need to contact either your landlord or plaintiff's counsel's office to see what you can work out regarding payment.
So I have to come into, this is in Chelsea, or Ann Arbor, Saline Road?
No, it's the court by the sheriff's department off of Washtenaw.
Oh, okay. How's that? Okay.
Okay.
All right. Thank you. All right. Thank you.
Northfield Estates versus Jason Armbruster. Jason Armbruster? No response. If you'd like to take a default, please. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, for the record, Rachel Dornbush, appellate law on behalf of the plaintiff. There's rent to retain of $3,006.99, cost of $217.80 for a total due of $3,224.79. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount in the amount requested with the writ issue 10 days. Northfield Estates versus Chad Gibbs. Chad Gibbs, no response. You may proceed.
Thank you, Your Honor. There is rent to retain of $179.32, cost of $217.80 for a total due of $397.12. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested with the writ issue in 10 days. I will indicate since it's under 200, no writ without a hearing. Court does call the case. Northfield Estates versus Tamara Coppens. No response. You may proceed.
Thank you, Your Honor. There is rent to retain of $2,016.99, cost of $217.80 for a total due of $2,234.79. And we'd ask for a default possession only judgment with writ issue after 10 days.
Judgment to the plaintiff. That is by default for possession. Redemption amount in the amount requested with a writ issue in 10 days. Northfield Estates versus Chris Woody. That matter is dismissed on plaintiff's motion without prejudice. Is that it for you?
Actually, Your Honor, my client just notified me. It looks like there were some additional payments on 2 accounts where I believe we can actually dismiss 2 of these defaults. It
Say
is
again.
Yep, the
Okay, go
Chad
ahead.
Gibbs matter, Your Honor, the 25-4C-0671 LT. This was the default no writ without hearing.
Yes.
My client advised that they have paid in full, so we would like to not proceed with that judgment and instead submit a dismissal. And same with Jason Armbruster, 669 are the last 3 on that case. They are also paid in full, and so we would like to not proceed with the judgment in that case and instead dismiss.
Okay, and matters based upon that are dismissed without prejudice.
Perfect. Thank you, Your Honor.
Thank you. Take care.
Bye-bye.
Bye-bye. Bishop Pickering versus Andrew Rich.
Good morning, Your Honor. David Fantair on behalf of the plaintiff.
Okay, Mr. Rich. He's at the access point.
Yes, he is.
Can you unmute yourself, sir, or hit the space bar? Thank you.
Hello,
Hello, Mr. Rich.
how you doing?
Okay. How much is owing?
Your Honor, I'm
Yes.
here, they got me here for non-payment of rent, but I paid my rent.
Okay, hold on. Let me see what they're claiming. Mr.
Yeah, I got my
Fantair,
receipt in my pocket.
hang on, hold on. Mr. Fantair, how much is plaintiff claiming is owed?
His current balance is $956. And he is correct that he made a payment since we filed the case, but he missed payment a couple months ago. So he's 1 month behind when he makes his payments.
That's not true.
All right, so Mr. Rich, here's what I'm gonna do. I'm gonna adjourn this to May 30th, 2025 at 12 p.m. noon. That's an in-person hearing. Why don't you bring all of your receipts to that hearing? And then you can go through them with the attorney along with the ledger and see what's been paid and what hasn't been, okay?
Right, but what I was trying to say, I get my check, my disability check on the 25th and the 26th every month. I'm always early. I never ever not pay.
Okay, all right, Mr. Rich, I can't decide that right now. That's why I'm gonna put it out a week. You bring all of your receipts, they'll have a ledger, and you can go through all of that, or we can go through it and try to figure out if you owe anything or not, all right?
Right, because I got my receipt here for this month, and I paid it, and the same day that I paid my
Mr.
rent.
Rich, I hear you. I need you to come down next week, bring all of your receipts again with you. There'll be a ledger here, and we can go through it and try to determine if you're missing a payment.
I'm not missing no payments, no way.
Okay, Mr. Rich, that's the best I can do. We'll see you next week. Noon.
What date?
May 30th.
May, we write that down, May 30th. What time, 12 o'clock?
12 noon.
12 noon?
Yes, sir.
Yeah, they got me tripping. They got me saying I'm
Okay.
always, my rent is always.
All right, thank you. We'll see you then.
Will I be coming in person?
Yes, sir.
I would like to come in person because I'm not good with these computers.
Okay, it's an in-person hearing. You'll come right down to the court, bring your receipts, they'll have a ledger. We'll go through it.
Okay.
Thank you. Bishop Pickering versus Holly Hollis.
Good morning, Your Honor. David Fantair on behalf of the plaintiff. The current balance on this case is $1,539.
You said $79?
1539.
39. All right, Ms. Hollis, how are you intending on getting that paid?
I filed for SCR through M Bridges, and I've been paying on my rent every couple weeks because I had lost my job and I had, fell behind. And
Okay. So how many people are in your household?
Just by myself.
Okay. So the max that they're gonna pay on that is $410. Okay, for an SCR. But here's what I'll need you to do. I'm going to, first of all, adjourn your case to May 30th, 2025, 12 noon. That's going to be an in-person hearing. Okay? And you'll need to file in your paperwork, you would have seen a rental assistance form. You'll need to file that with the court by Wednesday. If you don't have it in your paperwork or can't find it, you can either use the QR code that's on our screen, or you can come down to the court and get the form.
Okay, sounds good.
Okay?
Yes, sir.
All right, thank you. We'll see you next week.
All right, have a good day.
You too. Sandy McFiddish versus Stephanie Sims.
Good morning, Your Honor. David Fancher on behalf of the plaintiff. The current balance on this case is $2,125.
Okay. Ms. Sims?
Here, Judge.
Hello. How are you intending on getting this paid?
Your Honor, can I interrupt, please?
Yes, go ahead.
So Ms. Sims and I spoke either Wednesday or yesterday, and what we agreed on was if she pays $400 or $500 before next Friday, then when she comes to court next Friday, I'll give her a payment plan.
Okay.
And she understood that, and I think she agreed with that.
Is that correct, ma'am?
Yes, sir.
Okay. Well, you guys are making it easy for me. So you got to do that by the 30th.
Yes,
and
sir.
then I'm going to adjourn your hearing to May 30th, 2025 at 12 p.m.
Yes, sir.
noon. Okay?
Yes, sir.
Great. Okay, thank you. We'll see you then. Have a great weekend.
You as
So
well.
when you make that payment, then give it a couple hours and then call me, and we'll figure out what you need, and I'll do a conditional dismissal, okay?
Okay, yes, sir. Thank you so much.
Thank you. Sandy McFiddish versus Donovan Alexander.
Good morning, Your Honor. David Fancher on behalf of the plaintiff. The current balance on this case is including court costs, is $1,685.
Mr. Alexander, how are you intending on getting that paid?
I could pay it off within the next 30 days.
Okay, so you're gonna need to try to arrange something with the plaintiff. How much can you pay before next week?
Up to $500-$600.
Okay.
Your Honor,
So you need to you need to pay $500 to $600 by the 30th.
By the 30th.
And if he does that, I'll give him what he needs on the balance.
Okay. All right. So get that paid. I'm going to adjourn the hearing to the 30th, May 30th, 2025 at 12 noon. Try to get that paid like the 29th if you can. And then when you come into court, it'll be something where you might be able to arrange so we can get you caught up, okay?
Okay.
All right.
Okay, yeah, okay. Thank you.
All right, thank you. You have a great weekend.
You too.
Sandy McFiddish versus Jalea Thomas.
Good morning, Your Honor. David Fancher on behalf of the plaintiff. The current balance on this case, including court costs, is $2,325.
Ms. Thomas, how are you intending on getting that paid?
I'm working on getting in contact with Hawk Housing Assistance for Washington County. That's the best thing I have right now. The house wasn't in the best living situation or suitable situation for me and my child. I asked to be released from the lease. It didn't really work out that way, and so I actually moved. So I have to work out getting the money to them.
Okay, so hold on. You moved out of the premises?
Yes, I left April 15th.
Okay, did you turn in the keys?
The keys were dropped off, yesterday.
Yesterday? Okay, here's what I'm gonna do. Because they're requesting only possession of the premises. You still may owe the money. Hold on. But you still may owe the money to them. But this case is for possession of the premises. So if they can verify that you turned in the keys, this case may go away. Okay, you still may owe the money, but.
Ms. Thomas, who did you give the keys to?
I was asked to give the keys in the mailbox for maintenance. Well, it was the maintenance, but for the leasing officer, like my property manager for that place.
So is the apartment vacant?
Yes, it's been vacant since April 15th.
You've got everything out of there?
Yes.
Your Honor, I think with that representation, and there's nobody else living there, correct?
No, I actually had been asked to get let out of my lease due to plumbing issues, and they wouldn't try to let me. They tried to make me stay until July.
All right, well, we can figure that out later, but Your Honor, I think I can just dismiss this case based upon her representation that she's out. And
all right,
even if we can't find the keys, I think we can take possession.
Got it.
No, that's not the picture. I can actually bring it, but there's a picture of the keys in the mailbox at the place.
Okay. You surrendered possession on the record here. They're gonna dismiss the case and they're gonna take possession of the.
Okay.
Thank you.
No problem.
YPF 16 LLC versus Frenchie Alexander.
Good morning, Your Honor. David Fain.
And my officer's logging in.
Okay. Is this concerning Alexander Williams?
Yes. My officer's a night shift officer, so
Okay.
I knew the first case was supposed to be a waiver, so I'm like, sleep a little longer.
So this one's probably going to evidentiary as far as you know?
I guess that depends on what Mr. Ambrose announces.
Okay, fair enough. Okay.
Chris, do you need a visit?
We'll just be having a prelim on this one.
All right. And this is Mr. Williams, correct?
Yes, Your Honor.
We are on the record missing. We are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. This matter does come on for preliminary hearing in case number GW 2025 CR 26, State of Kansas versus Alexander Lavon Williams. Please announce appearances.
May it please the court, the state appears by Judge Roulette, County Attorney.
The defendant, Mr. Williams, appears in person via Zoom with counsel Christopher Ambrose of Harvest Legal.
And parties are ready to proceed with preliminary hearing?
Yes, Your Honor.
They are.
All right, Ms. Gillette, you may call your first witness.
Your Honor, we'll be calling Deputy Blake Fisher.
And I would note that the felonies that we're going to be addressing, count 1, Violate Offender Registration Act, count 1, and count 2, possession of opiate, opium, narcotic, or certain stimulant. The remaining counts are misdemeanors and 1 infraction. So those are the 2 felonies. Deputy Fisher, would you please start your video? Would you please raise your right hand, sir? Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may lower your hand, and Ms. Gillette, you may proceed to inquire.
Would you please state your name for the record?
Deputy Blake B. Fisher
And how are you employed?
by the Greenwood County Sheriff's Office
How long have you been so employed?
since December of 2019.
And were you on duty on Saturday, March 1st, 2025?
I was
Where were you on duty when you came across the defendant?
on US Highway 400 at the Greenwood Wilson County line.
And what drew your attention to the vehicle he was driving?
The vehicle had a defective headlamp.
Did you effectuate a traffic stop?
I did.
And when he stopped, where did he stop at?
At the approximate 351 mile marker in Wilson County, Kansas.
And did you call Wilson County officers also to the scene to assist?
I did.
And during that traffic stop, what was the first thing that you noticed when you approached the vehicle?
That the passenger wasn't wearing her seatbelt.
And what's the next thing that you did when you approached the car?
I asked for driver's license and registration, and both were provided.
And was there insurance on the proper insurance on the vehicle?
There was not, no.
And after gathering their information, what did you do next?
I went to my patrol vehicle and I ran the driver's license through my in-car terminal.
And when going through the in-car terminal, what did you find out about the defendant and the passenger?
The defendant was a registered sex offender, and the deputy on scene from Wilson County informed me that he had...
Objection, hearsay.
Sustained unless he's available.
Now, besides finding out information from Wilson County, you noticed that he was a registered offender. Are you the offender compliance officer?
I am.
And do you routinely do offender checks for Greenwood County?
I do.
And is there a state system to monitor those?
There is.
Did you check later his offender registration?
I did. I believe I checked it on scene, and that vehicle he was in was not on his offender registration.
And did it appear to be his routine vehicle that was the vehicle he drove?
It did.
And did you look up his last several registrations?
I did later.
Was this vehicle registered on any of his last several registrations?
Not to my knowledge or that I saw, no.
After you dealt with running their information, what was the next thing that you did?
I approached the window and I asked for Mr. Williams to exit as his driver's license is not valid.
And what happened when you tried to take him into custody?
He became somewhat resistant.
And did you end up having to arrest him?
I did.
And did you pat him down?
I did.
Then what did you do next? Was the vehicle properly registered?
I don't believe so.
Did you make notes consistent with the time and date of when you had this case?
Video.
And do you have an independent recollection of it?
Jill, he's talking over me. And
I'm sorry, is the defendant talking over you?
yes, he's saying lies, and when
Okay.
you're asking me questions, he's talking.
All right, Mr. Williams, you can't talk. You'll get a chance to talk to your attorney and see if you want to testify or not, but you can't just interject and talk over the officer. Make some notes and you can go in a breakout room with your attorney and talk about it after the testimony if you need to, but Deputy, please make sure he has something to make notes with so he'll remember what he wants to address with his attorney if he does. Go ahead, please.
Deputy, after you took him into custody, what was the next thing that you did?
I removed, I apologize. I removed, but while I was taking him into custody, I was removing a dagger from his person for officer safety purposes. I believe you asked me that question. And then once he was taken into custody, he was removed to the rear by my patrol vehicle.
Now, after he was taken into custody, was Miss Boland taken into custody?
No, she was not.
And was she placed anywhere? This time frame was in March. Was it warm or cold that day?
It was colder outside.
And after she was out of did you take her out of the vehicle?
I did, and she was placed in the Wilson County Sheriff's Office patrol vehicle.
Was she patted down prior to being put in that vehicle?
She was. I asked for consent and she gave it to me.
And after you had them both in custody, or what did you do next?
I started to tow inventory log of the vehicle.
And at this point, was the vehicle legally insured?
No, not that I was made aware of.
And did the vehicle have legal tags?
No, not that I was aware of.
Right. So when you started the tow inventory, did anything grab your attention?
There was a plastic bag seated on the rear floorboard directly behind the front passenger seat of the vehicle.
And did you go to inventory that bag and see if there's anything of value?
I did. There was a pair of brass knuckles.
And after finding the brass knuckles, was there anything else on the back floorboard?
There was a container that had a Applebee's label on it that contained an alcoholic beverage inside of it.
And were you able to determine whether or not it would have been alcohol?
Yes.
What did you do after you found the alcohol?
I started a probable cause search of the vehicle to ensure there was no other open containers inside the vehicle. While searching under the front driver's side.
Hang on, I'll ask you that part. You can't keep going. I gotta ask you questions. Did you find anything in the front driver portion of the vehicle?
Under the front driver's seat, I located a glass methamphetamine smoking pipe with residue.
And then, did you end up testing that residue later?
I did.
And, did you find anything else under or around the driver's seat?
There was another glass smoking pipe with residue that had been broken.
Okay. Did you locate anything in the center console?
May I refer to my report?
Will that aid in
Just
your
recollection.
recollection?
Yes.
And you may refer to it to aid in your recollection.
You asked specifically in the center console.
And, did you send the items to the KBI lab for testing?
I did.
Your Honor, I believe that Missy has the KBI lab in this case.
Missy, do you have that? Is that something we can screen share? Or do you
I
want me to
think
just look at
so.
that? If you have that and can screen share it, unless there's any objection to screen sharing. Is there anything on that, Ms. Gillette, that we wouldn't want publicly viewed?
No, it's the same kind of KPI report we always have.
Okay.
I
No
actually
social-
don't have that one. I had the one from earlier, but I don't have that one.
Your Honor, I don't know why Missy doesn't have them because we usually email those. I would ask to present the KBI lab separately. So that's why they're usually pre-emailed to Missy.
Mr. Ambrose, is there any objection to her proffering the contents of that lab?
1 second, Your Honor.
Very well.
If not, we can use field test results, Your Honor, for purposes of preliminary hearing.
I'm checking something, Your Honor.
Sure, go ahead.
Sorry.
Not a problem. Are you not at your normal desk, Ms. Gillette, where you can screen share it?
I am not.
Okay.
I have to pre-scan those, so.
Just, hey, for prelim purposes, Ms. Gillette, why don't we just use the instant test? I'm not seeing that I have a copy of the KBI result in my file yet. It doesn't mean you didn't send it. It means that I've not seen it in my file. So
Deputy, did you field test the residue in the pipes?
Yes,
And did they test positive?
yes.
What did they test positive for?
Methamphetamine,
And was there other drug paraphernalia and drug found within the vehicle?
marijuana,
Was that in the form of a vape pen?
yes,
And that's labeled as THC?
yes. And Jill, I'd like to restate, you had asked me if the tags on the vehicle were bad. They were not. It was only the insurance.
And I believe that covers all of the felonies, Your Honor. So I will pass this witness to the defense.
Very well. Mr. Ambrose, cross-examination.
yes, Your Honor. So Deputy Fisher, you had indicated that you had stopped Mr. Williams, or you had indicated you were you when this occurred, when the stop occurred, was your vehicle stationary or were you patrolling?
I was stationary.
And was your vehicle at the 351 mile marker then?
No.
On the highway? Okay. Where was your vehicle at?
I was on the Greenwood Wilson County line, on the Greenwood County portion of the line.
And when this traffic stop began, was this vehicle what side of the Greenwood Wilson County line was this vehicle on when you hit your lights or however you began your traffic stop?
When I observed the violation, it was in Greenwood County.
And what time of day was it when the stop occurred?
Nighttime.
You had indicated that there was a defective headlamp, is that right?
Yes, the driver's side headlamp.
was, in what way was it defective?
It was going out. I can't recall if it was completely out. I mean, I know that it was not visible at least 50 feet in front of the vehicle. It was out or nearly almost out.
Next, you had, just so I'm correct, Miss Bolig was the passenger, is that right?
Correct.
And you had indicated that when you had walked up to the vehicle after the driver had pulled over, that you had indicated that that passenger wasn't wearing a seatbelt at that point, right?
Correct.
Were you able to observe if that passenger had a seatbelt on while the vehicle was still driving?
No.
You had also indicated that at the time, the vehicle wasn't compliant, or at the time of the stop, Mr. Williams wasn't able to provide you with current insurance for the vehicle. Is that right?
Correct.
Did he provide you an insurance card?
No. I can't remember if he did. I remember that we were on the phone with his mother. Miss Bolig did provide me an insurance card, but it was expired. And throughout the whole stop, we were on the phone with Mr. Williams's mother, and I was never provided with any current proof of insurance on the vehicle.
Okay, so but the insurance card you had been provided was expired then, okay?
Correct.
Do you recall when it had got, just out of curiosity, do you recall when it had expired?
I do not know.
And it's not in your report, is it?
I don't believe so, no.
Thank you. Now you had indicated that you are the registration compliance officer for Greenwood County. Is that right?
I am.
Okay. What does that all entail?
Ensuring that everything on each offender's registration is up to date and accurate.
And with that, you are, have you had any extra additional training for that, or how did you become that individual?
It was appointed to me by the sheriff, and I have been to some training for it, yes.
What kind of trainings have you been to for it?
The KBI has hosted a training on it.
Okay. Just so we're clear, what kind of training was that?
I can't recall. It's been years ago.
Okay. And with that, I'm not going to ask that question. It's going to ask for him to draw a legal conclusion. I'll withdraw that.
Okay.
And then, so in the course of this stop, you ended up doing you started out by doing a tow inventory, and then you found what you would believe to be alcohol in an Applebee's cup during that tow inventory. Is that right?
Correct.
Okay. And when your department finds what's presumed to be an open container, what steps are taken to ensure that that's actually alcohol?
I mean, there wasn't enough in the vehicle to send it off for testing or anything. Some of us have a PBT that reads it. I don't. I was just able to tell that it was alcohol based off the odor of it. And it was later admitted to me that Mr. Williams had been drinking from that cup, and it did have alcohol inside of it.
And was that a statement by Mr. Williams or someone else?
Someone else.
And Your Honor, I'd move to strike that as hearsay then, if that individual is not here to testify today.
Sustained.
Now, going back to this inventory stop, to the Applebee's cup, and then as a result of that, you began searching the vehicle for other open containers, right?
Correct.
And during the course of that, you found these 2 pipes, right?
Correct.
Where were they located again?
Underneath the front driver's seat.
Both of them were?
What?
Or it was 2 pipes that were recovered, right?
Correct. Underneath the front driver's seat of the vehicle.
And in the course of that, in the course of the stop, did anyone take responsibility for those pipes?
No.
And you had tested them with an instant test kit, correct?
Correct.
What instant test kit do you all use?
The mobile detect.
And what is the procedure for the mobile detect kit for getting a result?
There's a strip, and you get some of the substance that's inside of the pipe onto the strip, put the strip in, it tests the substance, and I scan it with my phone, and it will detect or not detect whether there's an illegal substance.
Counsel, is this going to help on the probable cause for counts 1 and 2?
For the methamphetamine possession kit charge, yes, Your
Oh,
Honor, that's why I'm
okay,
asking.
okay. I thought you were talking still about the alcohol. I missed that.
No, I'm sorry, Your Honor. No.
No, you did it. You did everything fine. I'm sure I just missed the term.
Yes, Your Honor. And so was that the policy, was that the procedure you followed this evening? Or the evening of the stop?
Yes.
Okay. And I don't believe I have any further questions of this witness, Your Honor.
Ms. Gillette, any redirect?
No, Your Honor.
All right. Any further witnesses, Ms. Gillette?
No, Your Honor, the state will rest.
Mr. Ambrose, any evidence?
I have a breakout room for 1 second with Mr. Williams.
Yes, certainly.
Judge.
Please, Missy, help them with that breakout room.
Once we have him back, Judge, we'll continue on.
All right. We are back on the record in GW 2025 CR 26, State versus Williams. All parties as before. Returning from a brief recess, Mr. Ambrose, any announcements at this point?
Judge, we won't be putting on any evidence today. And I believe we'll be waiving any closing statements. However, I will ask to be heard on bond before we're done this morning.
Very well. Ms. Gillette, any closings?
Judge, I believe that he's driving a vehicle. It's his primary vehicle. It's not on his offender registration. Hasn't been on his offender registration for the last several registrations he's done as to count 1. Count 2, the methamphetamine pipes are under the driver's seat within reach of the driver in his car that he drives as his primary vehicle.
I do find that probable cause exists to bind this defendant over for arraignment. Missy, when will that be?
This case will go to Judge Hart. I have June 12th at 9 or July 3rd at 9.
We can do June 12th if we might.
Very well. The defendant is ordered to reappear with counsel before Judge Hart for arraignment June 12th at 9 a.m. Counsel, you want to be heard on bond?
Yes, Your Honor. Right now, Mr. Williams has been in custody for a while, basically since this case got filed.
March 1st.
Yes, Your Honor. And he lacks the financial means to post bond at that level. However, in speaking with him, if the bond was to be reduced to $10,000 cash surety, I anticipate he would be able to post bond at that level.
So where does he live or where is he from?
I can give you an address in 1 second. He'd be residing in Iola, and if I remember correctly, it would be with his mother.
Is that right, Mr. Williams?
Yes, ma'am, it is.
Did you reside with her before you were brought into custody?
Yes, ma'am.
All right. Were you employed when you came into custody?
Not at the moment. I was in between jobs.
All right. How long's your mother lived in Iola?
Oh, for a long time.
Okay. Ms. Gillette, your response to the motion to reduce to 10,000?
Your Honor, the defendant has a hold from Wilson County on a current active warrant, and did have one. I let the sheriff's office know that it is still popping up in Odyssey on his flee and elude case, to go over there and finish that case when he is done. So I would say that the $10,000 cash security warrant is appropriate, or bond is appropriate on him.
All right, bond is reduced to 10,000, cash or professional surety required. Anything further on this matter? Make sure, Mr. Williams, that you have no alcohol, no illegal drugs in your possession or anywhere about. Don't go where it's being offered. Ms. Gillette, does he need to stay away from this? Was it the passenger you said in the car?
It would be preferable since she also was engaging in any behavior or habits.
Is she, what is she? Is she a wife, a sister? What's her relationship to you, Mr. Williams?
Soon to be wife.
Soon to be wife. Where
Yeah.
does she live? Does she live with your mother also?
No, ma'am.
Okay. Have you been having contact with her here in the jail?
I haven't had contact with too much of anybody.
All right, well, and Miss Gillette, was she charged with anything? I heard she wasn't.
She was charged with things.
Okay.
She wasn't. No, she
Well,
wasn't.
she was not. Well,
No, she was not.
well, I'm gonna order. What's that, Miss Gillette?
I'll double check.
Well, for now, I'm going to order no contact, and then when you get in front of Judge Hart in a couple weeks, you can ask him about it. But if you haven't had any contact right now, you don't need to have any when you get out for a few weeks.
With my wife, I can't have contact.
What? You keep saying a lot of things kind of under your breath there. What did you say, sir? Do you want me to hear
I
it?
was speaking with the officer next to me. Thank you.
All right, watch your tone. Getting a little elevated there. Could get you in
And-
trouble.
Judge, we don't have anything else today. However, if I could have a breakout room with her real quick before we set off for today, I'd appreciate it.
With your client again?
Yes, Your Honor.
Yes, that'd be fine. And Deputy Fisher, thank you for your time. You are excused. Ms. Gillette is excused, I think. And then as soon as you're through at the breakout room, we'll just close out because Missy, we don't have anything else until this afternoon. Is that right?
We have an 11 o'clock.
Oh, okay. All right. Now, is it on the same docket?
Yes.
Okay, then I'll just hang loose and they can go into a breakout room. Thank you.
Yes.
Taxation.
Have a time to do.
Can you email and Jill will forward it when you as
We are on the record, Missy. We are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. This matter comes on for preliminary hearing in GW 2025 CR 19, State of Kansas versus Dustin Ray Corin. Please announce appearances.
May it please the court, the state appears by Judge Gillette, County Attorney.
May it please the court, the defendant appears in person via Zoom with counsel Christopher Ambrose of Harvest Legal.
Are we ready for prelim or are there any announcements?
We're gonna have a waiver today, Judge.
Very well. Mr. Do you pronounce it Corn or Corin?
Warren?
Corin?
Yeah. Yes, ma'am.
Mr. Corin, I'm told that you want to waive your right to preliminary hearing, and I legally have to go over some points involving that with you before I accept that waiver. Because you are charged with at least one felony, you are entitled to the preliminary hearing. And you're actually charged with 1, 2, 3, 4, 5, 6, 7 felonies, including distribution of heroin, possession of paraphernalia with intent to manufacture, possession of opiate, opium, narcotic, or certain stimulants, possession of marijuana after 2 prior convictions, identity theft with intent to defraud, interference with the law enforcement officer opposing a felony warrant, and taxation, drug tax stamp violations. There's also misdemeanor, but it is the felony charges that each entitle you to this preliminary hearing. At a preliminary hearing, the state has the burden of producing evidence to make it appear that each of these felony crimes has been committed and to show probable cause that you committed each of these crimes. Preliminary hearing is not a trial to determine whether you're guilty or not guilty. It is a hearing to determine if there's enough evidence to make you stand trial, or in other words, to be bound over for trial. At a preliminary hearing, you have the right to be present with your attorney, and you have the opportunity to challenge the state's evidence,
I'm currently in court.
to challenge the existence of probable cause for further detention, or for requiring bond or bail as to the felony charges. You would have the right to subpoena witnesses, cross-examine the state's witnesses, and present evidence on your own behalf. A preliminary hearing would apprise you about the nature of the crimes charged and the sort of evidence you would be required to meet if you were to stand trial. If you waive or give up your right to a preliminary hearing, there will be no preliminary hearing, and you will be bound over to the district judge for further proceedings. You will be required to appear at a later date before the district judge for arraignment, at which time you will enter your plea to the felony charges and that one misdemeanor. And until that time, you will be remanded to the custody of the sheriff, unless at some point you are able to make bond, and then you'll be obligated to appear under the terms of the bond. Have you talked with your attorney about waiving your preliminary hearing?
Yes, ma'am.
And do you need any more time to visit with your attorney before we proceed?
No, ma'am.
Do you want to waive your right to preliminary hearing?
Yes.
Are you voluntarily waiving this right?
Yes.
Has anyone made threats or promises to cause you to waive your preliminary hearing?
Nope.
Are you in good health today?
Yes.
Are you taking any medications which might impair your judgment today?
Not at all.
And Ms. Gillette, does the state wish to waive its right to a preliminary hearing?
State does.
Very well. The court does find that the state of Kansas has waived its right to a preliminary hearing. The court further finds that the defendant has made a knowing waiver of his right to preliminary hearing after consultation with counsel. It is the order of the court, therefore, that the defendant is bound over to the district judge for further proceedings. The defendant shall next appear before the court for arraignment. And Missy, when will that be?
This case will go to Judge Ricky, and he is available June 5th at 4 p.m.
Mr. Ambrose, will that work?
Do you have another date for him after that? I've got city court stuff then, but I might be able to work around it if we don't have anything else. Since Mr. Corn's in custody, I want to keep this moving as quick as I can.
The next one is July 10th.
Yeah, let's do this June 5th one. We'll make it work.
All right, your arraignment, June 5th at 4 p.m. Ms. Gillette, did you have a point?
Oh, I was gonna say there's a quick one that's going in the morning we might be able to do, or earlier in the afternoon.
We can send some emails about that back and forth, Your Honor, and see if we can work something out. We'll work it with his staff.
All right, Mr. Corn, that's what I will set your court date for, but your attorney and the county attorney are going to get with Judge Ricky and see if they can move up your arraignment. Anything else we need to address, counsel?
Not today, Judge. Thank you.
All right, thank you all. We'll be in recess. You may go, Mr. Corn, Mr. Ambrose, and I think that will conclude our docket. If there's nothing further, this docket is adjourned. Thank you all.
See you at 1:30.
On behalf of the plaintiff, the current balance on this case, including court costs, is $1,350.
Frenchie Alexander, no response. If you'd raise your right hand, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead, sir.
I'm David Painter. I'm the attorney for IPF 16 LLC, and as such, I'm familiar with the books and records as they relate to this tenancy. In this case, there's rent owing in the amount of $1,175, court costs of $175 for a total of $1,350. We'd ask for a judgment for possession with a written 10 days if that amount remains unpaid.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested. Writ issue in 10 days. 103 South Huron LLC versus Aaron Emanuel.
Good morning, Your Honor. David Fantera on behalf of the plaintiff. The current balance on this case is $2,215, and he's already been approved for money from SOS for the full amount. So I think if we just come back next week, we can do a conditional dismissal. Maybe it'll even be paid by then, but even if it's not, we'll just do a conditional dismissal and resolve it.
All right, Mr. Emanuel, is all of that okay with you?
Yes, sir.
Okay, you guys made this easy for me. I'll adjourn this matter to May 30th, 2025 at 12 noon. Okay, we'll see you then, and hopefully we got everything worked out at that point.
Is that in person?
Yes, it is, sir.
Okay.
All right.
All right.
Thank you.
Thank you.
And Your Honor, I've made life tough on you sometimes, so I guess I made up for it at least a little bit today.
That's right. It balances out. All right.
I'll see you this afternoon. Thanks, Your Honor.
All right. Thank you. Thank you, Mr. Manuel.
Thank you.
That's it for that block. Court stands in recess.
Cedric Simpson, preside.
Realty.
Good afternoon.
Nothing we can do.
Kevin Coy versus Greg Munzer.
Ellis Freeman on behalf of the plaintiff.
Oh,
Here, Mr. Munzer is his.
he's here.
Will you come up here?
Yes, right up here.
Or here, you just said here.
Oh. No, you're good. Here. Did you need hearing equipment?
No,
You sure?
I read
Oh.
lips pretty good.
What do you say?
I read lips pretty good.
Okay, we have equipment.
Yeah, no, I
Why don't we give it a shot? It's good stuff.
I have omniphase hearing. It's not bad hearing. It's just quite different.
Is that better for you?
Not really.
No? Okay.
It's too kind of artificial,
Okay. All right.
too
Gotcha.
echoey.
Okay. All right. Very good. All right. Where are we on this case?
Well, Your Honor, this is a termination case of month-to-month tenancy. There hasn't been a lease in effect in years. And there was a notice to quit given and the time has expired and we need possession of the property. We have some issues with Scioto Township with tickets and we need to get possession of the property. Simple as that.
All right. And Mr. Munzer, where are you on this?
Sir, I got sick. I brought in a doctor's thing. I was sick Wednesday. I was out just recovering. This will be my first day getting back there. I need another week, but I can be out. When you first asked me last week, I didn't want to hold up the thing. I thought I could be out. I got sick.
Okay.
But in a clean, workman-like manner, I've got a production line. Things are going out. The storage is rented 1 mile from there. Ample room for everything. Most of it's out. I have a bug infestation. They were all airplane hangars. There was a 2-inch gap around the ceiling and the roof vent. It just brings in bugs.
All right.
Stuff is.
So if I give you to June 6th, you can be out?
Oh, absolutely, sir.
All right.
Yeah.
Then what I will do is I will find no tribal issue after hearing out granted judgment for possession to the plaintiff with the writ the June 6th.
Thank you, Your Honor.
And let me say finally that I was out there on 2 properties that are adjoining. It's the old Young Airfield Airport
Okay.
out on Jackson Road.
Yeah.
I've been out there 38 years. I just want to also say this one point. I am singly the person that has moved more trash off those 2 properties than everyone else combined. And when I lost the help of the senior parents due to retiree, and then the sons did not, they just said, hey, just let it go. And before that, I hauled them out. I got with the sheriff, whatever it took. I've hauled over 100,000 pounds off that property. And my stuff is clean, neat, and in a workmanlike manner. It's going out the door. It's my dream to be finished the second I'm done, believe me. But no one has worked harder, more. I just, in the end, I'll make a call to the and tell them how grateful I am. The sons and the township, if I had to bring them in front of the judge, I promise you, there were things that you wouldn't do. Literally.
Understood. All right. Thank you, sir.
Thank
You
you.
have a great weekend.
And I
Feel better.
can't thank you enough. My whole life is, going to a next step and.
Gotcha.
I-
Okay.
Thank you.
Take care, sir.
Thank you.
Kevin Coy versus Tori McLean.
Ellis Freeman for the plaintiff.
They're not here.
No, sir.
Alrighty, you'd like to take it to poll. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
This is the same type of case, Your Honor. It's a termination of month-to-month tenancy. Notice was given. We know that the tenant is aware of it, and he's obviously just chosen not to appear. So we asked for default judgment. I'm fine with the same writ date.
Okay, judgment to the plaintiff by default for possession. No redemption, writ to issue June 6th.
Thank you, Your Honor. I'll see you about 2 o'clock.
Yes, sir.
Thank you.
And thank you for that, that packet. That saved me a trip.
Yeah, it's pretty, it tells a lot.
Yes, it does. It does. S&C Holding versus Ashley Nicely.
Ready, Your Honor.
Hello, I'm here. Sorry.
Okay, I need the camera. Okay. The last time we were before the court, I think there was 24, 52, 56 that was owing. Where are we now, if anywhere?
Your Honor, there should be in the file a consent order for a conditional dismissal that both the defendant and I have signed on behalf of the plaintiff.
Yes, it was tucked in the back there. I got it. Okay, let me just take a brief look at this.
And then I did make a payment last night of $1,000.
Okay, so you made the $1,000 that's
I did,
referenced
yes.
here. Got it. Okay. So makes sense. Ma'am, do you have any questions regarding anything contained on this?
No, I do not.
All right. All looks good to me. I will apprise you, and I will sign off on this conditional order dismissal. I will apprise you have 3 business days to think about it. If you believe that there's some legal reason, some confusion on your part, or some right you didn't serve, you'd have to file a motion with the court within that time frame. You understand that?
Yes.
All right, very good. This case is conditionally dismissed.
Thank you.
folks. Town Center Place versus Viola Hines.
Good afternoon, Your Honor.
Good afternoon. Good afternoon, Ms. Hines.
Good afternoon.
All right. And last we were here, there was about 1,500 owed, 1478.40.
SOS paid 1129 and Jewish Family Service paid the rest. And they're mailing the check to Town Center today.
Okay,
We haven't received it yet, so.
you haven't received it. So what happens with, they said they're mailing the check today?
Yes, Jewish Family Services. I was supposed to pick it up, but I didn't get away out there.
Okay,
So she called me
So-
this morning and said she would mail it.
so who's paying? You said SOS was paying part of it?
Yeah, they're paying 1129.
All right,
And-
do you mind if I ask?
No.
To determine, is that what you have, Amy?
Your Honor, I don't have a dollar amount. I just know that there's a coordination with JFS and SOS, and what she's speaking about is that checks don't need to be, make sure that it's in transit. But
Which check?
the JFS,
JFS check. Okay, but you do see that the whole,
that they're gonna resolve it with both of them.
with the 2 checks. Okay. So given that representation, counsel, what I'm gonna do, and hopefully then this can be dismissed, let me adjourn it out a week since we won't go into another month.
Sounds good.
And hopefully this will resolve itself. So May 30th, 2025 at
1 p.m.
1 p.m. And
Okay.
hopefully
Thank you.
those checks will get there. And you said so the Jewish Family Services, they now mailed the check.
Yeah,
As
today.
opposed to you getting, okay, all right,
Yeah.
okay. So then we can see where we are on it, do what we
Thank you,
need.
Your Honor.
Okay.
All right,
Thank you.
folks.
You have a good holiday.
You do the same. Linden Park Apartments versus Brittany Edwards.
Good morning, Your Honor.
Counsel, state your
Remember
appearance.
Andrew Gertis for the plaintiff. I'm sorry, I don't have much of a voice.
Okay, it's all right. A lawyer without a voice. I don't know if that's a good thing or a bad thing. I don't know. There are days I would appreciate that. Anyway. Miss Edwards?
Yes, hold on 1 second. I'm trying to turn my camera on, but it's not working.
Okay, there you are. We got you. Okay. We were at 3,059.15 last time we were here. Has that changed at all or?
Your Honor, the
Yes.
numbers, yeah, the rent to retain possession is $1,900. We have costs of $159.15. So we would be seeking a possession judgment of $2,059.15.
Okay, so basically paid 1,000. Is that correct, Ms. Edwards?
Yes.
Okay. And what is your, well, did you have a plan for that 2,059 or?
Yes, I do. Just like I said before, on the first court date, I can pay on the 28th, the full balance.
So you can pay everything on the 28th?
Yes, I can.
All right, since you paid the 1,000 and got that in, and you can pay it on the 28th of this month, I'm going to adjourn this out to May 30th, rather than give you a judgment, 2025 at 1 p.m. All right. And typically what happens, Ms. Edwards, if you get everything paid, you just got to make sure everything's paid. They're going to dismiss the case. Okay.
Okay, no problem. I do have a question though. On that day, I do have a surgery scheduled at the same time that you want to do the court date. So if my balance is paid, do I have to get on Zoom again?
No. If your balance is paid, then, and everything's paid off, just make sure that it is.
Okay.
Then if you don't appear, there's nothing for anybody to do except me. And let's dismiss it. Okay.
Okay. Thank you so much.
All right. Thank you. Be well, please.
You too.
Thank you, Honor.
All right. Thank you, sir. And then he showed up. Okay. Then I'll just wait for a moment. We can go off for a second.
She said she didn't when they patted her down. And as they were dealing with Mr. Malby, he said, well, I have something on me, and he had a bag of methamphetamine that later tested positive for methamphetamine at the KBI lab.
Okay. All right. Well, Mr. Maltby, it sounds like there's sufficient evidence to support the charge and your no contest plea and for me to find you guilty of the charge. I find that you're alert and intelligent. I think that you understand the nature and consequence of entering this plea. And as I stated, there is a factual basis. So I do find you guilty of unlawful possession of a controlled substance in the state of Kansas in violation of 215706 AC1, specifically methamphetamine, which is a level 5 drug felony. I'm going to order a pre-sentence investigation. I'm going to set your case over for sentencing. That usually takes 6 to 8 weeks. So a month from now would be June 23rd. And then 2 weeks from that, I'm looking at my calendar and my available date is July 17th. So not quite 8 weeks, but a little over 6 weeks.
And Judge, I'm in a jury trial that whole week.
Okay.
Got a Jessica's little trial somewhere.
Judge, in anticipation of the plea, Ms. Morgan has sent a packet to the jail for Sierra to give to Mr. Maltby before he leaves, or for him to fill out if he gets a bond today. And they will help get him the number for court services there.
Okay. Do you have any idea, Ms. Gillette, where he's going to fall on the guidelines and whether or not he'll be presumptive prison?
I'm hoping that he will screen in for Senate bill based on what we believe his criminal history to be.
Okay.
That's accurate, Your Honor.
Okay.
We truly want him to get treatment.
Can you do it Friday, July 11th at 11 by Zoom?
That'll be fine, Judge.
Hang on, let me look at July 11th.
Prelim day.
I've got a prelim July 11th. No, it's a payer up here on a traffic ticket. So yep, I'm good on July 11th. We'll have.
Okay. All right, we'll do your sentencing Friday, July 11th at 11 a.m. Now, you have to have appointments with court services. They'll set you up, they'll screen you for substance abuse, and they'll screen you for risk assessment needs. And if you don't keep those appointments and follow through and take care of that, then I won't be able to sentence you on the 11th. And in all likelihood, I'll put you back in custody if you make bond. And that may sabotage your chances of probation if I have any discretion about it. So I really need you to stay focused and your mind good and clear and follow through on this stuff so that we can, do a final disposition of your case on July 11th.
Okay.
Okay, and what is the request for bond?
Judge, our request today is going to be an own recognizance bond for Mr. Maltby. He has been in custody for a little bit of time. He is of very limited financial means. We did get him lined back up. He's back on track. Like Ms. Gillette said, the state and myself anticipate that this is going to end up being a Senate bill case. Would further note that Mr. Maltby currently has someone staying at his residence, helping to take care of some animals. However, that person's going to have to leave soon. So he does have some substantial concerns about that as well. And frankly, Mr. Maltby, I think understands the situation he's found himself in. I did not explain this to him. However, the court does, even if the court grants Senate bill, there's always the discretion that if he has issues to make him serve up to 60 days as a condition of probation before he's allowed out at sentencing. So I believe he has every motivation to do what he needs to. And so at this point, we would be asking the court to contemplate granting him an own recognizance bond.
Is there an objection to that, Ms. Gillette?
Judge, I don't have an objection to that. That we've already sent a packet over. He missed his pretrial conference for his jury was supposed to possibly plea, and then the jury trial was canceled, and he showed up one of the days that we were supposed to be having jury trial and got arrested. So I'm fine with releasing him based on the fact that he forgot the pretrial, but he came on the jury trial day.
Okay.
And then his packet is already at the jail, and if Sierra will write down the phone number for court services, he can call them. And Ms. Morgan sent the phone number over 316-322-4153 so that he can get his PSI started and get that paperwork turned back in.
Okay. And you have Mr. Ambrose's number. Stay in contact with him. If you have questions, he can answer any of your questions. I
Yes,
will give you a $5,000 OR bond. A condition of that bond is to complete the requirements of the PSI and to reappear on July the 11th and 11th.
I will do that.
All right.
Thank you.
Make sure you get what forms were sent over to the jail filled out before you leave, though.
Okay.
Okay, thank you. All right.
Yeah.
Anything else, council?
Hidden Gardens versus All Occupants, 2403440. Good morning, Ms. Kingsley.
Good morning, Your Honor. Brandon Kingsley appearing on behalf of the plaintiff.
Is anybody here for the defendant at 25821 Telegraph, lot 44?
I've not had anyone check in on Zoom, Your Honor.
Okay, so I'm not sure what we're up for on this one, Ms. Kingsley. Can you enlighten me?
Yeah. So this is plaintiff's motion and petition for disposition of the mobile home that's situated on the lot that my client owns. So the last registered leaseholder, his name is Gavin Thompson, leased the property site, lot number 44 for my client. Prior to initiation of the original termination of tenancy action, my client had apparently
Stop you 1 second. Do you have that motion, Jennifer?
Judge, it should be attached to the back of that packet. I did print it.
All right, I'm sorry, Ms. Kingsley. Go ahead.
Thank you, Judge. So it's our understanding that my client entered into an agreement outside of court with Mr. Thompson to turn over title to the mobile home in lieu of his past due balance at that time. However, when he turned in the title, it's marked as Exhibit B to the motion. It was torn apart, and it appears that he had never transferred title into his name from the individual that he purchased the home from. So the home is a 1969 Champion. It remains titled in the name of Orla Forrest Miller and Phyllis Jean Miller. Now, both of them are deceased. My office was able to get in touch with their next of kin, Philip Miller. We had some really good discussions with Philip about basically filling out a form called a TR-29, which allows next of kin of those that are deceased title holders to transfer their interest. He has since become non-responsive and has elected not to participate in this process with us. They've been served, Philip has been served. There were numerous other individuals that last chance letters were sent to as well. Those were marked, attached to my motion as well, I believe as Exhibit F.
I don't have any of the exhibits to this I'm gonna need, Jennifer. Look, here's what I'm gonna do. I'm adjourning this a couple weeks. Let me go back and look at all of these things, okay? Today is the 5th. We're gonna adjourn. I I just need to look at the paperwork here. I don't know what happened. I didn't see this motion on the bottom. I'm gonna adjourn it to May the 12th, right?
No, Your Honor. We have a docket on the 15th. The
Okay.
12th, you're not available.
Oh, that's right. We'll make it 8:30, okay, counsel?
Okay,
Do you have another one here?
I do.
I don't know what to do. I'm gonna either need papers for all of these, Jennifer, or do you? So I'm gonna send this down with John and make sure I get a copy of all these materials plus the exhibits, okay?
Okay,
Yeah.
Judge, I'll look at it because I know it's 36 pages and I thought I printed the whole thing, so.
Okay, no problem. So sorry about that, Ms. Kingsley. I'll get that order for you next week. I got some concerns about it, obviously.
I know we've been through this before, so.
I know, but this one sounds even stranger. So you had somebody living in the mobile home that wasn't even the titled owner and somebody else owns it. Now we got heirs involved and I don't know how you're gonna, I'm gonna go back and read your motion, but I don't know how you're gonna rectify that.
Okay.
So I'll take a look and I'll talk to you next week on that, okay?
Sounds good.
Thank you. I don't even know what I'm doing.
There were two motions, Your Honor, this morning, and Granite Tella Valley has one as well. I believe it's for the
I
same.
see. Granite Tella Valley versus Kimberly Louise Kepke, 2404351 LT.
Good morning, Your Honor. Corey Grandmason, Swistak Levine, representing Granite Tella Valley.
All right, you can go ahead and proceed. What happened is I signed the writ and the 56 days elapsed.
Correct. In these types of matters where there's 90 days to sell or remove, generally the writ needs to be renewed. In order to renew a writ under the Summary Proceedings Act, has to be done with a notice and a motion after 56 days, and that's what we've done here.
All right, so the defendant failed to appear. Is anybody here for Kimberly Louise Kepke?
No, Your Honor, defendant has not appeared.
All right, defendant having failed to appear, the motion is granted.
I'll submit the order via e-file then, Your Honor. Thank you.
Order to be submitted by plaintiff. Thank you. Anything else?
That's it, Your Honor. I appreciate your time.
Have a good day. Thanks. FC Stratford LLC versus Jesse Gutowski and Damon Gardner, 2501523.
Good morning, Your Honor. Mark Swain appearing on behalf of the plaintiff, P number 82148.
All right. Is anybody here for the defendant? Is Jesse Gutowski or Damon Gardner here?
I am. I'm Jesse.
Okay. Can you tell me your name?
Jesse Gutowski.
Where's Mr. Gardner?
He doesn't live here. So it's just
You guys sent a second mailing here, correct, counsel?
I believe so, yes.
All right. So, ma'am, I'm going to ask you this. Did you look at the video?
yes,
You listened to all of it?
yes,
Did you understand all the rights?
yes.
All right. Now, you wish to speak to a lawyer?
No,
All right. Have you submitted an application for funding?
yes.
When did you do that?
I don't have the dates. It was for DTE though. It wasn't for.
No, with regard to the rental property here.
No, I didn't.
Do you intend to?
No, because I have to pay April and May together. So I was going to have both of them payments on May 30th.
Do you want to speak to her, counsel?
Sure.
If you don't, that's fine. Ms. I mean, if you do, I'm gonna go ahead and take the rest of his cases, Ms. Gutowski. You can just mute yourself there. I will pass this case. I'll go on to another one, and Mr. Splain will see if he can resolve this with you, okay?
Okay, thank you.
All right, thanks. FC Stratford LLC versus David Rembiz and Hannah Love, 2501554.
Good morning, Your Honor. Mark Splain appearing on behalf of the plaintiff, P number 82148.
Do I have either Mr. Rembiz or Hannah Love here?
Yes, this is David Rebish.
Okay, good morning. Is Hannah Love here?
No, she is at work.
All right, so she has to show up on these, okay? One of you can't just show up and represent.
Oh, okay. My apologies. I did not fully understand. So.
All right, I'll just make a note that you were here. Did you listen to the rights?
Yeah.
The video?
Yes.
Did you understand it?
Yes.
Do you wish to speak to a lawyer?
No.
Have you applied for funding?
No, I did not, because I mailed my rent in. Because I spoken to the property manager, Valerie, and I told her I mailed both March and April's checks in. And I'm just at the mercy of the mail right now, so they should be in any day.
Mr. Splain, has your client received any funds from Mr.
I have no indication that we've received those funds, Your Honor.
When did you mail them?
On Monday. So like I said, it should be within any day that they should be getting that, because I've mailed it via regular mail. I wish I mailed it certified.
Why?
Because the office is closed, and like late payments have to be made via cashier's check, and then
somebody has to sign for it. Listen, here's what I'm going to do.
Yes.
Got to pay your May rent at this point. You understand that,
Yes,
right?
I have the funds for the May rent too, so I just need I want to make
Why
sure.
don't you get with her? Whoever Ms. Love is, whether it's your girlfriend or whoever else needs to be here next week.
Okay.
I'll make a note she failed to appear.
Okay.
I'm going to adjourn this 1 week, Mr. Splain. You good with that?
That's fair, Your Honor. Thank you.
May 12th at...
The 15th, Your Honor.
Oh, I don't know why I keep saying the 12th all day.
Because that would normally
I know. At what time? At what time?
9:30.
9:30?
Yes.
All right, good enough. That's what I'll do. So we'll put that over.
I have one quick question. When the funds, because the funds should be there in any day, and
well, you got to go take care of May.
Yes.
Communicate with management. Make
Yes.
sure they receive the other funds. They should be there by now. I mean, it's not like mailing it from Juneau. So go over there and make sure of that. Make sure you pay the May rent, and they'll dismiss.
Okay, perfect. So yeah, I'll take care of that.
Your Honor, is this by Zoom or in person?
Zoom.
Okay, thank you.
Okay, thanks. Good luck, Mr. Rebiz. Make sure Ms. Love's here next week.
All right, thank you, Your Honor.
May 15th, that's next Thursday. FC Stratford versus Giovanna Perkins, 2501555.
Good morning, Your Honor. Mark Splain appearing on behalf of the plaintiff.
Is Giovanna Perkins here? I don't.
Yes, Your Honor.
Yes, she is.
Oh, okay, ma'am. Your name?
Giovanna Perkins.
Good morning to you. Did you listen to the video?
Yes, sir.
Did you understand all the rights?
Yes, sir.
Any questions on the rights?
No.
Do you wish to speak to a lawyer?
No.
Have you applied for funding?
No.
You intend to apply for funding?
No, sir.
All right. How much is owed here, Mr. Splain? Can you just give me the total amount without breakdowns right now?
Total amount is $5,897.79.
I'm sorry, how much?
$5,897.79.
Ma'am, you're going to be able to pay that? You agree that you owe that?
I have the payments for March and April, but because we're into May and I have to pay that as well, it's going to take me 2 more checks to get the rent for May. But I have March and April, but they just don't accept partial payments.
Here's what I'm doing. I'm gonna adjourn this 1 week, May the 15th. You make sure they get the April and March payments and be prepared to pay on the May payment within a few days at least. So May 15th at 9:30, you can be here again, okay?
Okay.
So make sure you pay April and March today, all right?
Okay.
Okay, so you can do that today?
Wednesday, sir.
I thought you said you had it.
Without the late fees, because I didn't know it was 5,000. When I look on it, it gives me something else. But yeah, tomorrow. Is tomorrow Wednesday?
Tomorrow's Tuesday, Wednesday's.
Wednesday.
Ma'am, how much do you have you can pay to them on Wednesday?
Well, I get my paychecks I get paid Wednesday of every week. That's why I said Wednesday, sir.
I didn't ask you that. I want to know how much you're going to be able to pay. You said April and March you have.
Yes, I have.
How many can you pay them on Wednesday?
3,500, sir.
Okay, Counsel, I'll do that for you, but if you don't have it all paid up, I'm going to give them a judgment next time on May 15th, okay?
Okay.
All right, I wish you well. Good luck.
Thank you.
FC Stratford versus Deborah Barnes, 2501556. Is Deborah Barnes here? Deborah Barnes did not show, Jennifer? This is the second, there was a mailing, second mailing done as well, so it does not appear as though she is here. I don't see her in the screen, on the screen. Nobody else is in the courtroom. So counsel, I'm prepared to give you a default.
I would love that. Thank you, Your Honor.
Can you give me the breakdown, please?
Yes, sir. Rent to retain possession is $3,289.98. There's costs associated with this of $189.79 for a total of $3,479.77.
Do you have any late fees that are included in this?
Hang on. Late fees for rent, you're saying?
I don't know why you're not coming in that good. It's like a microphone that's.
I apologize, Your Honor. Is that better?
Not really. Maybe a little bit. That's a little better. It sounded like with the but anyway, how much are your late fees? I capped those at I think 75 a month now. I think that's what I said last time. Or 10%, whatever is lesser, I believe.
Late fees are $50.
Okay, good enough. They're all included in your.
Correct. Yes.
All right. Submit your order. Defendant failed to appear. Default judgment's entered. Your judgment, I should say. Writ date will be May the 15th. If you can get that over to me early this morning, okay?
Thank you, Your Honor.
FC Stratford LLC versus Alyssa Pinkston, 2501564. Good morning, Ms. Pinkston. Your name, ma'am?
Alicia Pinkston.
Okay, you got to stay close to that device.
Can you hear me?
I can hear you a little better now. Yes. Can you repeat your name?
Okay.
Can you repeat your name?
Alicia Pinkston.
Did you listen to and understand the rights on the video?
Alicia Pinkston.
Yeah,
Yes.
I heard you. Wait a second. Is there a delay here? Just stay right there. We're getting a decent connection. Don't go
I'm
walking
sorry. I'm in
around.
a
Hang on.
hospital.
Wait.
Let me step outside. Give me 1 second. I'm going to the front. Can you hear me now?
I can hear you, but I can't have you walking around. I will not conduct the hearing if you're walking around. So I'm gonna give you 30 seconds to wherever you're gonna go, and then we're gonna start, okay?
This crazy Zoom stuff. I'm sorry. Nope.
Okay. Wait, you gotta keep. Okay, just stay right there now. Did you listen to and understand the rights, Ms. Pinkston, on the video?
Yes.
You wish to speak to a lawyer?
No.
Do you, did you apply for funding?
No.
You intend to? Do you intend to?
No, not at this moment. I haven't looked into the options yet.
Well, if you decide to, within 5 days, you have to submit proof that an application has been submitted for processing with one of the agencies, Department of Health and Human Services, Local Coordinated Entry Agency, Housing Assessment and Resource Agency, or the Federal Help for Homeless Veterans Program.
Okay.
Counsel, tell me how much, if I didn't ask your appearance on this, will you tell me your appearance and how much is owed, please?
Splain appearing on behalf of the plaintiff.
I'm sorry?
Mark Splain appearing on behalf of the plaintiff. Rent to retain possession is $3,340.40. With that, there's costs associated of $189.79 for a total of $3,530.19.
Can you pay that, ma'am?
Is that for April and May together?
That is correct, yes.
Yes, I can have that payment May 30th. Unfortunately, I did speak with the property management. I am laid off from my job, and then I just recently lost my son last Saturday. So I'm trying to get everything together and get my money together. I can't have the payment for April and May by March 30th. I'm sorry, by May 30th.
I'm sorry, did you say you lost your son?
Yes, I just lost my son last Saturday.
Oh my God, I'm very, very, very sorry. It's horrible. Here's what I'll do on this one. I'm gonna let you and Mr. Splain go into a breakout room and speak about this one, okay? So if you'll just be patient, I'm gonna get through the rest of his cases. I think there might only be one more. And then I'm gonna have to go in with somebody else and then with you, okay?
Okay.
All right, I'm really sorry for you. I really am. FC Stratford versus Anastasia Ward, 2501565. Okay, good morning, Mr. Splain.
Morning, Your Honor. Mark Splain appearing on behalf of the plaintiff.
Is Anastasia Ward here? There you are, ma'am. State your name, please.
Anastasia Ward.
Did you listen to and understand the rights on the video?
Yes.
Do you wish to speak to a lawyer?
No.
All right. Have you applied or do you intend to apply for funding?
Yes.
You have applied?
Yes.
With who?
Sarah, the state of Michigan.
All right. Okay, here's the deal. I'm going to adjourn this 2 weeks. You have to provide proof. You have to provide proof that you've made application for funding within 5 days.
Okay.
Okay, so you have to bring that up to the courthouse. This will give you an adjournment for 2 weeks. Am I doing, what is it, the 19th?
That's correct, Your Honor, and we'll do that at 9:30.
At 9:30 in the morning, okay?
Okay, so I just print out basically me showing that I applied, right?
Judge, there's a form she can fill out here at the courthouse if she could stop in.
So you can just stop into the courthouse today or tomorrow, okay?
Okay, thank you so much.
All right, May 19th, good luck. Thank you. All right, so Jennifer, why don't you put in Mr. Splain with
Gutowski and Pinkston is the two, correct?
Correct.
Okay, I'll get a move between them.
Thank you. Tanglewood versus Todd Wade, 2501558.
Good morning, Your Honor. Brandon Kingsley for the plaintiff.
Mr. Wade has not appeared, Your Honor.
All right, and there was a second mailing, counsel. You can go ahead.
Thank you, Your Honor. I have rent to retain in the amount of $993.93. Late fees of $100, that's $50 for 2 months. Court costs $189.79, total $1283.72 with a writ to issue in 10 days.
Excuse me. Defendant failed to appear. Default judgment's entered. The amount to be paid to save it is $1283.79. The writ date in this case will be on May the 15th. Again, defendant failed to appear and was given his 15 minutes. Do you have any more, counsel?
Thank you, Judge. Nope, that's all I have.
Have
I'll
a
see
great
you.
day. Yeah, thank you. All right. Gibraltar Point versus Emily Marshall. 2501560. Good morning, ma'am. Your name?
Emily Marshall.
All right.
Jen Wilburn, P8343 for plaintiff.
What's there? You already called it, 8:30, she just showed up.
What happened with it?
She said she just checked her mail today and got it.
Just checked her mail today?
Apparently she doesn't look at that or something.
Was that with Stratford?
That was. Brad Televalley.
I already ruled on that.
That's what I told her.
You gotta show up on time, man.
My manager.
You gotta show up on time. I already,
Told me to be here at 9:00.
you got court notices from us. I told you.
I know, I just.
It was scheduled for 8:30. You'll have to go down the hall and they'll tell you what to do, but you gotta be here on time. Wait, shh. I'm not gonna carry on a conversation. I'm sorry, I can't do that.
How do I make an appointment?
You can go down and talk to the civil department, okay? All right, Ms. Marshall, did you listen to and understand the rights on the video?
Yes.
Do you wish to speak to a lawyer?
No.
Did you apply or do you intend to apply for funding?
No, I was just concerned because I don't want the eviction on my record. I had a family emergency and I couldn't pay my rent.
Slow down a second. Ms. Wilburn, can you tell me how much is owed? I don't need a breakdown now.
So inclusive of the court costs, we're looking at a balance of $2,209.17.
Can you pay that today, ma'am?
I cannot.
Well, when can you pay that?
I can't. Like 2 months. But I want to leave. Almost everything in my apartment is moved out. I just have to move my couple big things and
Here's what I'll do. I'm gonna let you go into a breakout room with Ms. Wilburn when we're done, okay?
Okay.
She's got other cases. She's at least got one more, I see. I don't know if you have another apartment complex. If you do, you can tell me when we're done, but just be patient and we will put you in a breakout room with Ms. Wilbur and see if you can resolve it, okay?
Okay, thank you.
Thank you. Portia Russian, Gibraltar Point versus Portia Russian, 2501562. All right, where is Ms. Russian?
Hello, I'm here.
Oh, okay. Your name, ma'am?
Portia Russian.
All right, Ms. Wilburn, your appearance?
Good morning again, Judge. Jen Wilburn, P83143 for plaintiff.
Ma'am, did you listen to and understand the rights, Ms. Russian, on the video?
Yes.
You wish to speak to a lawyer?
No.
Do you intend to apply or have you applied for funding?
No.
How much is owed? Can you tell me, Ms. Wilburn, on this one?
Yep, Judge, $2,184.17.
Can you pay that, ma'am?
Not today.
When?
Can I pay 1,000 on the 8th and the remainder on the 28th?
Does that include May's rent, Ms. Wilburn?
That does include May, Your Honor.
I'm going to put you in a breakout room with Ms. Wilburn right now, but I'm going to put her in with somebody else first. I'm going to go on to another couple cases, and you guys can see whether or not you can resolve it, okay?
Okay.
So just be patient. She's going to speak to somebody else first. Do I have Jesse Gutowski back in here? Have you talked to her, Mr. Splain?
He was just getting ready to go in with his other one. I'm not sure if he went
Good
to the
enough.
breakout room.
Good enough.
Yes, we talked.
All right, he might be talking to the other one. Just be
No,
patient.
he's back. He's
Here, Your Honor.
All right, FC Stratford versus Jesse Gutowski and Damon Gardner, 2501523. All right, Mr. Spain, your appearance again.
Mark Splain appearing on behalf of the plaintiff.
Ms. Gutowski,
Yes.
your name.
Oh, Jesse Gosowski.
What, any resolution?
Your Honor, she said, we're gonna give her some time to pay. She just needs, she's a student. I understand that she's having a tough time, so she said she can pay something by the 23rd and then the balance by the 30th. So leave it up to you, Your Honor.
Well, are you guys gonna enter into a consent judgment, or you want me to just adjourn it a week or two?
If we could adjourn it to the week of the 26th, then if she has made the payment, then we'll work with her, but if she hasn't, then we'll get the
No
judgment.
problem. Give me a date that week. I know I'm not here the 27th.
Yes, we're doing the 29th at 1 p.m.
So, ma'am, you gotta pay them up by then, okay? Or else I'm gonna have to give them a judgment, all right?
Okay.
So I'll adjourn it to May 29th at 1 p.m. But again, you have to get with them and pay them before that date, okay? Otherwise, I'm gonna give them a judgment on that day, all right?
Okay, thank you.
Good enough. Did you speak? Thank you, ma'am. Did you speak with Ms. Pinkston, Mr. Splain?
Not yet, Your Honor.
All right, go into a breakout room and do that, and I'll go on to another case here.
Your Honor, if I may, the progressive housing is Miss Ellis or Wilburn, excuse me. If we could do that one so she can talk to the other two.
Progressive Housing versus Joseph, forgive me, Zweko,
Yes.
SEWEKO 2502025.
Yes.
Morning again, Judge. Jen Wilburn, P83143 for plaintiff.
Morning, Mr. Zweko, your name?
Joseph Zuko.
All right. All right, Mr. Zuko, did I pronounce that correctly?
Yeah. Yes.
Did you listen to and understand the rights on the video?
Yeah.
Do you wish to speak to a lawyer?
No.
Do you intend to apply or have you applied for funding with any of the agencies?
No.
How much is owed on this one, Ms. Wilburn?
Right now, Judge, we are looking at an outstanding balance. It's $46.21 for the rent, and then
Court costs.
$261.42.
So you owe somewhere in the neighborhood of about 48 to 93.62, I think.
48.82.42.
Say probably wrong again, right? Okay, at any rate, that's what you owe. Can you pay that?
No, I can't pay that right now. I just made a payment of $800 though.
Here's what I'll do. I'll put you in a room to speak to Ms. Wilburn too, okay? So she's got a couple others, and I'm gonna let you go into a room and speak with her, but she's got a couple others ahead of you. You guys can see if you can work it out, all right?
Thanks, Judge.
Okay, thank you.
Thank you. All right. Marion Manor versus Aaron Martin, 2501595.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Good morning, Ms. Austin. How are you?
Good to see you, Your Honor.
Thanks. Good to be here. Where is Ms. Martin? Is she here? I thought. Did she show up, Jennifer?
I did have her checked in, Your Honor. Let me make sure she's not stuck in the, I don't see her. She's lost connection and I don't have her waiting.
Let me go on to the end of that and let's see if we hear from her, okay? At the end of this apartment complex, maybe you can, I don't know what to tell you. Marion Manor versus Austin Hart, 2501597. Is Austin Hart here?
Yes, Your Honor.
Good morning, sir. Your name?
Austin Hart.
Ms. Austin,
Oh, I'm sorry, Your Honor, Rebecca Austin for plaintiff.
did you listen to and understand the rights, Mr. Hart?
Yes, Your Honor.
Do you wish to speak to a lawyer?
No, Your Honor.
Do you intend to apply for funding, or have you applied for funding?
No.
I got it. Are you at work right now, sir?
No, sir.
You just dressed up like that for court?
Yes.
Well, I mean, I compliment you.
Thank you.
I really do. You look great. Jeez, it's about time. That's the way people used to dress. Still should, but now I get them in pajamas. All right. Well, thank you for doing that. How much is owed on this, Ms. Austin?
The total, Your Honor, do you want me to break it down?
No, just total.
$2,392.23. That does include May rent.
Can you pay that, Mr. Hart?
Not today, Your Honor, but by the 16th, I can pay the $985 plus the $85 late fee for April and the remaining balance on the 30th of this month.
You're not charging $85 late fees in there. I know you wouldn't do that.
70, Your Honor.
Yeah, what did I tell you before? I was trying to remember. I haven't been doing landlord tenant. Was it 70 or 75?
I think it was 70.
Okay, I take your word for it. You were the one who pushed me and pushed me and pushed me.
I was behind that, Your Honor.
The landlord tenant lawyers owe you a cup of coffee. All right. Do you want to talk to him, or do you want me to just adjourn it out a couple weeks? You tell me.
You know, I'm happy to talk to him, Your Honor, see if we can then avoid the next hearing and put him on a payment plan through the end of the month. I can probably accommodate those dates.
I'll put that date, I'll put that aside, Mr. Hart. And I'm going to let her talk to you, but she's going to have somebody else ahead of you, and we got people shuffling in and out. So just be patient if you would, please, okay?
Okay.
Thanks. Marion Manor versus Teresa Stack, 2501598.
Rebecca Austin for
Hello,
Good morning, Ms. Stack. Your name?
Teresa Stack.
Did you listen to and understand the rights on the video?
Yes.
Do you wish to speak to a lawyer?
No.
Do you intend to apply, or have you applied for funding?
No.
Ms. Austin, I don't remember if I asked your name yet on this case. Can you state your appearance again?
Rebecca Austin for plaintiff, Your Honor.
How much is owed total balance on this?
$2362.54.
You gonna be able to pay that, ma'am?
Not today, but I should be able to pay part of it.
You're cutting in and out. Hang on, slow
before the end
down.
of the
Wait,
month.
you're cutting in and out.
I'm sorry.
Just get close to your device.
Hello,
Yeah, get close to your device and tell me when you can pay this.
I am. Okay, I can't pay it all I cannot today, but I can pay some in 2 weeks and then the rest at the end.
Hang on. I don't know what's happening. You're probably gonna have to show up in person next time, okay? Because I'm just,
Okay.
I have to record these proceedings and I'm missing every third word. What do you want to do with her?
Your Honor, it sounds like she also wants a payment plan from what I mean, I'm happy to talk to her in a breakout room and.
So we'll put you in a breakout room after she speaks to the others, ma'am. Okay?
Okay.
Mary Manor versus Demonica Brown,
Good morning, Your Honor.
2501599.
Rebecca Austin for plaintiff, Your Honor.
Is Demonica Brown here?
She did not check in, Your Honor.
You paid for a second mailing, you can take a default.
Your Honor, I'd request a possession only default judgment, rent to retain. The rent is $943.51. There's a $70 late fee, so that totals $1,013.51. Court costs of $176.54. Total judgment $1,190.05.
All right. Defendant failed to appear. The relief request will be granted default judgment possession in favor of plaintiff and against defendant. The amount to be paid to save is $1190.05, you said, correct?
$1190.05, yes, Your Honor.
Writ date will be on the 15th of May. If you can get that to me early this morning, okay?
Your Honor.
Thank you. Marion Manor versus Corey Running, 2501600. Corey Running here.
No, Your Honor.
You paid for a second mailing, you can take a default.
Good morning, Your Honor, Rebecca. Your Honor, this is a possession only default judgment. Rent to retain $2,600.
Wait a minute, you're cutting out now. Getting a horrible, can you repeat that, please?
Sure. Rent to retain $2,600.53.
You kind of went down when you put your head down. I didn't catch the rest. 2,600.
1.53. $170 late fee. So the total $2,671.53. Court costs of $176.54 for a total judgment of $2,848.17.
Defendant failed to appear. Default judgment will enter. Writ date will issue on, the writ date will be the 15th. The amount to be paid to save it from the issuance of the writ is $2,848.17. So I'm going to put this aside and I'm going to let you speak to, in this order, Ms. Martin, Mr. Hart, and Ms. Steck, okay? And I'll recall those as soon as you come aboard and tell us you're ready.
Property manager in those rooms with me. Can Jen do that when she moves us?
Sure.
I will do my best.
Thank you. Okay. Let's see. Mr. Splain, are you ready on yours yet, sir?
Yes, Your Honor.
FC Stratford versus Alicia Pinkston, 2501564. Ms. Pinkston, your name, ma'am?
Alicia Pinkston.
Morning again, Mr. Splain.
Good morning, Your Honor. Mark Splain, appearing on behalf of the plaintiff.
Any resolution?
Your Honor, we're going to ask for an adjournment, the same adjournment from May 29th.
We'll adjourn this to May 29th, Jen. Was that 9:30?
1:30.
Or what did I give you? What'd you give me?
1 o'clock. Sorry, I thought I was
PM.
unmuted.
That's okay. At 1 p.m. So that's it for you, right, Mr. Splain?
That is it for me. Thank you, Your Honor.
Thank you, ma'am. I'll see you on that date. Good luck. Try to pay them before then, and then he can dismiss, okay?
Okay, thank you.
Thank you. Good luck.
Thank you. Bye.
All right. Who has another case ready? Does anybody have a case ready for me right now that I've already called?
Not yet, Your Honor. I've got both attorneys still in rooms.
That's fine. You just let me know when they're coming out and what case.
I will.
Call if you would.
Court does call the case of Arbor Commercial Realty versus Scott Sendes.
Good afternoon, Your Honor. For the record, Tim Dvorsky appearing on behalf of the plaintiff, Commercial Realty LLC.
Scott Sendes, Your Honor.
All right. And where are we on this, John?
Well, I thought we were going to be able to resolve this, but we were unable to. So I guess we're going to have a hearing, Your Honor.
So what's the issue?
Well, I'm not really quite sure. The tenant wants 6 months to move all of the stuff out. That's one issue. And I told him that we can't provide him 6 months. We can give him a little bit more than the 10-day statutory period. And the other thing is that he feels for one reason or another that there was an agreement that if he moved out, which he still hasn't moved out, that he didn't owe any back rent. Did I accurately?
Correct.
Those
Yeah,
are.
we had a verbal agreement that if I was to move out, that I would no longer be paying the rent. I told him I couldn't pay the rent and move out. And I thought we had come to a mutual agreement that it would be best for both parties if I just moved everything out.
And it's my client's position that no agreement was made. And even if one was, the client still hasn't moved out and still wants another 6 months to move out, Your Honor.
Sir, you're not disputing that the rent's owed.
Well, I am, because I had an agreement with the landlord to, if I moved out, in lieu of paying the back rent.
Which he hasn't moved out, even if there was an agreement.
But I'm in the process of moving out.
But really, guys, I hear you. You guys can keep repeating it, but I can.
I'm sorry, Your Honor.
From one moment to the next. I get it. So, I mean, there are two parts, so that you understand this, sir. There are two parts of this case. One is the possession issue, and then the monetary issue. In terms of the possession issue, I don't see that there's an issue for me to try, because the condition of you staying is, first of all, to pay rent. Even if, I'm not saying that I'd make a finding that there is, even if there is this other agreement that you move and you don't owe the rent, the only bearing that has on the possession issue is you were supposed to move, right? So I can bifurcate the hearing so that we deal with just the possession issue and then set it for a further hearing as to the money claim. But if I do that, then the question is when are you going to move? Because I think they'd be entitled to a judgment for possession. And the reality is that if I do that, finding no tribal issue on the issue of possession, it's going to be 10 days. I can tell you that even using my discretion, I wouldn't give you 6 months to move. So if we just deal with that part of it, when can you be out?
I mean, I said realistically 6 months because there's so much stuff. I understand that that's not agreeable with them. But I've tried to work with them. I even offered another solution to conduct a liquidation auction. But I said, even that's going to take, probably 2 months realistically, and everything still won't sell. So I did make a promise that I would clear the property out in lieu of not paying rent, that I would make sure that it was, left empty. And that's why I came up with the 6 months, because I know that's still going to take time, even after I liquidate a vast majority of the stuff. It's still going to take time to remove the junk, and I'm willing to pay for the removal of all the trash that's in there and leave it empty. But I don't think that's agreeable.
Well, they've said it's not agreeable.
The other problem I'm having is I just found out recently, a few minutes ago, that the person I've been dealing with apparently is no longer the owner of the property. So the person that I've been dealing with, the person that I had a verbal agreement with, I guess is no longer, making the calls. And I was not aware of that, which I guess explains why I haven't heard back from the person that I had made this deal with, because I just found that out a few minutes ago.
Well, Your Honor, speaking to that aspect only, the owner's still the owner. The son has been managing the property for the last year or so. So I don't know I think that's what you're referring to, correct?
I guess I just meant I wasn't aware that the person that I was talking to isn't actually running the operation anymore. So when I was told, I won't charge you any rent if you can move everything out, and at the time I talked to him last, I didn't give him a time.
That's, again, the problem with that is, if I assume that's true, you haven't moved.
I'm in the process.
Which means if you haven't moved, that means you still owe the rent, right? Which means they'd be entitled to a judgment and you'd still owe the money.
But the agreement that I had was that I wouldn't be paying anymore if I moved out.
But you haven't moved out.
Correct. I'm in the process of moving out.
Well, according to his own words, Your Honor, that's a 6 months ordeal. So, I mean, I could say I'm moving out of my house by taking a dish at a time.
Well, this isn't a one bedroom apartment. This is a 10,000 square foot warehouse packed to the rafters with stuff. So it's not, it took several years.
I get back to my same question. For you, how much time are you looking at? 6 months is not going to happen.
Okay.
So here, just let me finish this. The statutory period would be 10 days.
Right.
I get the circumstance that you're in, so maybe that's not realistic that it's 10 days.
Right.
But I can tell you that even if I use
the furthest reaches of my discretion to give additional time, it's not going to be near 6 months.
Okay.
And so if you guys can't decide, I'm going to pick a date on the possession issue, and then I set it for trial on the monetary issue. But you guys are going to have to decide. It's going to have to be something realistic, sir. I mean, they're entitled to the possession of their property by even what your agreement was. They're entitled to possession.
I mean, I can guarantee I can't move everything out in 10 days. It's not.
How much, what would be the fastest?
I mean, 4 months, is that agreeable?
No, that still puts us in the same position.
It's, like I said, I've probably moved half of it out within the past, 3 months. It's gonna take, I would say, at least 4 months, realistically.
I mean, no.
We'll let Your Honor make that decision.
That's really don't want me to do that. Nobody gets happy then. But what's that? Trial date, July. Thank you. Listen to everybody. As to the issue of possession, I'm going to find that there's no tribal issue as to the issue of possession only. I'm going to issue an order of eviction on or after June 30th.
After what, June 30th, Your Honor?
Yes, June 30th.
Thank you very much.
I will also on the monetary, on the damages and money issues on the case, I'll set a trial on that matter for July 15th. 2025 at 9 a.m.
Thank you. And I will prepare the order on the possession. I'll submit it to the court. I'll submit a copy to you.
Will I be getting a copy? Because that's the other thing. I haven't received any court summons or anything.
Well, we have a proof of service in the file, Your Honor.
What do you mean you haven't received any summons?
The only summons that I received was the one on the tape to the door, and
well, that's service.
I was under the impression that I was also supposed to be mailed something as well. The one that was taped to the door had the address in Saline, which is why I wasn't here at noon, because I went to the courthouse in Saline and they said, "Oh, you're at the wrong place." And then I called the number that was on the summons, and the number was for Wayne County Courthouse. So my summons that I received on the door was little.
So what do you want me to do with that? You're here. I've heard your case.
I'm just saying, am I going to receive?
Yes.
Mailing?
I'll tell you what. Here's what we'll do. You'll get a judgment. Prepare a judgment. I'll sign it and I'll give you a copy. Thank you.
The judgment up at the counter.
Yes, get a judgment out at the counter, sign it, and then get it all prepared, and then I'll do that.
Thank you, Your Honor. Hold on.
Harbor Woods versus Masheri Taylor.
Good afternoon, Your Honor. Sydney Fine, LMP 86316 for the plaintiff.
And good afternoon, Sydney. Your name?
Mashari Taylor.
All right. And where are we on this case?
Your Honor, I believe that last week was the hearing on the motion to set aside the dismissal and reinstate case, and so you adjourned this for a second hearing. My understanding is that she was expecting to get some payment from some agency, so I would inquire as to what the status is about that.
Great.
We haven't heard from them yet, but we're still waiting on what they say, how much we're getting. And I won't get paid for my job until next Friday, I believe. And I had called them to see if they can work with me, but the office said they won't.
Hold on a moment. So first thing, let me start here. There was 2,053 that was supposed to be paid May 16th. Did that get paid?
Your Honor, so I do show that that was posted to the ledger on May 21st. Would you like me to run through what's currently due?
Pardon?
Would you like me to run through what's currently due?
Yes, please.
Yeah, so there's rent due of $9,421.78, court costs of $185 for a total of $9,606.78.
$606. What was the cents? I'm sorry.
78 cents.
78 cents. Okay, so you did make that payment.
Yes.
Okay, because it dropped from the last time that we were here. Okay. And then how much were you supposed to receive from these other individuals?
I think it was 6.
6. I remember you saying 6 because I thought we were still going to be about 3 short.
Yeah.
With everything. But
I think
then you say you get paid on the 30th, and how much is that?
It depends on what how long the job was this whole entire week. But usually it's about 3 or maybe 4.
3 or 400. Okay, but that doesn't help kick this balance up because even if, let's say it was the maximum of 4, I'm still $3,200 short.
Yeah, and I was trying to see if they could work with us because I know I can pay next month's rent on time. It's just the back rent I need to pay off. And I was trying to work with that, see if I can.
Okay, but here's my problem. My problem is this 6,000 or thereabouts, we don't know when that's coming or if it's coming.
Yeah, I don't know.
Right. And so if the 6,000 doesn't show up, then you don't even necessarily have a plan as to how there's 9,000, almost 9,500 gets paid. Right?
Yeah, but I was getting help from family and friends with the rest if the 6,000 came.
All right. Well, I don't really have anything.
And I have a
Go ahead.
And I have an appointment with Hawk coming too.
Okay, but here's gonna be the problem. And I think you might have mentioned something about Hawk before.
Yeah.
If the 6,000 was paid, right?
Yes.
And you said that came in, and then you get to, say you got 400 from your check. So you knock that off. Then I'm at about $3,200, not going into June. And then if you can find a way to get 200 and Hawk had the money, they would pay 3, but you have to get this balance under 3,000 before Hawk's gonna do anything. Right?
Yes.
So that's the problem. It's the logistics of trying to, as to when these payments are in. But even at this point, I can look at all of that, but at this point, I don't even have the 6,000. And that's gonna be the biggest chunk of all of this. All right, so who's supposed to pay the 6?
My mom knows the name of the people. I can't remember it.
Mom here. Come on up, who's supposed to pay that?
It's through the agency, it's a community health agency that's my cousin. We gonna be over her health.
Pardon?
Her health care to help her in the house. So they giving us a lump sum because they owe us for that. That money is coming, so we should know somebody next week with that because we talked to the lady the other day.
Okay. All right. Okay, here's what okay. I hear you. I don't have anything to try in the case. Okay, I reinstated the case on this. You made that one payment. I think if the 6 came in, maybe your landlord will work with you to try to do that. But even if the 6 comes in, and then you can get another 6 and work with Hawk, you might be able to secure that other 3. You follow me?
Is 9,000,
It's
right?
9, but if the 6 came in,
Uh-huh,
then that would take you down to about 3,600.
right, and Hawker,
Hawk's maximum is 3,000.
correct.
But that, you'd have to get all of that accomplished before June kicks in. Because June is gonna kick that
Yeah,
balance.
that's the problem, their dates is out far, so, and you usually can't get a
Right,
date
but
without a,
Hawk isn't gonna do anything.
correct.
They can't even make a promise to you because you have to, you would have to show them that this balance is gonna be under 3,000 or 3,000 or under. Right? I mean, that's gonna be the problem. All right. But I don't have anything to try here, so I'm gonna grant a judgment for possession to the plaintiff for the $9,606.78. What I will do is give you a little bit of additional time with a writ to issue June 6th over the objection of plaintiff. So if maybe, and by putting it out to the 6th, if you can get the 6 into them, get to Hawk, let them know the position that you're in, and then make sure that your June rent gets paid on time.
Correct.
And then find 600 to get yourself at that $3,000 threshold, and just hope and pray that Hawk can come through for you.
Yes.
You can do it. That's the only way I see this possibly
Okay.
working. Okay, folks?
Mhm.
All right. So that's what I'll do.
Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case of Arbor Woods versus Felicia Hugan
City Fontanelle.
and Reginald. I'm sorry, and Reginald Hugan.
City Fontanelle for the plaintiff. Your Honor.
Pardon? The Hugans are not here, which is odd. Well, would you like to take a default?
Yes,
Do you
please.
solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
Thank you, Your Honor. Your Honor, there is current rent due of $1,331.91. Court costs of $242 for a total of $1,573.91. And I would request writ to issue after June 2nd, 2025.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days.
Thank you.
Thank you. Court calls the case of Arbor Woods versus Brittany LaFloria.
City Fontanelle for the plaintiff, Your Honor.
Hello.
Hi.
What's your name?
Brittany.
And what is plaintiff's claim on this case?
Your Honor, so I believe that Ms. LaFloria has been speaking with Ms. Dornbush from my office, honestly, quite a bit today. And so we did discuss some concerns she had with the balance. And so what I'm showing for rent is $342.30, court cost of $186 for a total of $528.30.
$528?
Yeah, and 30 cents.
That's owing.
Yes. That is
As
what
of our agreement from today.
Yes.
Hold on a second. Well, she's made a heck of a lot of payments then.
Your Honor, so if I may, there haven't been
Yeah.
payments made. There's been some credits that we've discussed, and so my client is going to be providing credits to the ledger, and so that's the balance that would be due after the credits have been applied. Miss LaFloria stated that she could have this paid by June 2nd, I believe, and so what I would request is just a judgment today with her to pay that by
For
June
that
2nd.
amount. Is that correct? That you can have this paid by then?
Before then.
before then?
I couldn't make it today because they have to adjust the ledger online, so I couldn't make the payment yet
Got it.
until they come into the office after the holiday.
Okay, got it. Okay. So what I'm gonna do is I'll find no tribal issue after a hearing. I'll grant a judgment for possession for the $528.30. All right, and with a writ to issue June 2nd or thereafter. So you have that time to get it paid.
Okay,
All right?
thank you.
You have a great weekend.
Thank you, Your Honor.
Court calls the case of Barbara Woods versus Dominique Lucas.
Cindy Fontanella for the plaintiff, Your Honor.
Hello.
How you doing?
Okay, what's your name?
Dominique Lucas.
All right. Okay, what do we have her balance?
Your Honor, I'm showing that her current rent due is $3,237.16. Court costs of $186 for a total of $3,423.16 currently due.
All right. And what do you have to say? Did you make you didn't make the payments you said you were gonna make?
No, I had some issues come up, so I had to use the money for my car.
This is your monthly rent.
$14.49.
How are you gonna try to get this paid?
I have 700 today, and I can make the rest of the, what was that, be 2736, I believe, by June 4th.
Okay, so you're saying you can get this total amount paid by June 4th?
Yes.
Okay, so here's what I'm gonna do, young lady. I'm gonna find no tribal issue after hearing. I'm gonna grant a judgment for possession for the amount of the $3,423.16. And writ issue, I'll make it June 6, 2025. Over plaintiff's objection, maybe. All right, so you got to the 6th to get all that.
Okay.
I would get, if you got the 700 day, get that into them, so you get that balance now.
Okay.
This judgment doesn't include anything having to do with your June rent.
Okay.
It's just the back portion.
Okay.
Okay?
I got a question for you.
Okay.
I
have an answer for you. No, I don't know. Maybe I don't.
I seen you in February. When I seen you in February, did you include March's rent into February?
Whoa. You're okay. I would love to be able to answer your question, but I've probably seen, I don't know, how many cases.
Yeah. Okay.
So what was the date in February? You know?
I don't remember the date in February, but I know I had to have everything paid by March 10th, which I did. I don't remember the date in February.
Just a second.
Was it February 28th?
Give me just a second. Let me see what I can find in our system.
She was here in January.
Was it January?
January
24. Okay, I don't see a judgment in February. I see a judgment in January.
Okay.
Yeah, it looks like there was a judgment entered on January 24th.
Oh, sure.
I'm her mother. Okay, come on up with your daughter. What are you, because you're gonna sit up there and yell at me from the back. What's your name?
Luella. Hi. I think the questions that she's asking when she was in here in January, from her understanding that the February or whatever the following month was included within that balance.
Okay.
And I think this is where she's getting off a track.
Gotcha. So I can't say for sure, but I can tell you that generally, if the judgment was January 24th, February rent was not included in that.
Okay.
Okay, that would only included what was due then.
Okay.
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 All right.
That's good with me.
See, it's good that you have your mom, because I understood what she said. I didn't know what she said. No, I'm kidding.
Thank you.
All right. Thank you. You take care. Court calls the case of Arbor Woods versus Alicia White.
Sydney Fontanella for the plaintiff.
And Michaela White. Neither one are present. You may proceed.
Thank you, Your Honor. I am requesting a default judgment. There's rent due of $3,400.56, court costs of $242, for a total of $3,642.56, and I would request a writ to issue after June 2nd.
Judgment to the plaintiff by default for possession, redemption amount, in the amount requested. Writ to issue in 10 days. Northfield Estates versus Carl Riemann.
Sydney Fontanella for the plaintiff.
That you, sir?
I'm Carl Ryman.
All right. All right. This is a termination case, and you adjourned us out for you to seek the advice of an attorney. So where are you now on this case?
I adjourned it to seek advice. I failed to get any attorneys to get involved. I got warning that I'd be postponed a week last week. And then that never followed through to get anything more further done. I just counting on my Apple phone for a computer these days. I'm just, at a lurch of, was just living as feeble as I am these days with, my brother just got committed to hospice this week, and I'm just, mixed up with, just trying to pay off, see how I survive my sewer bill or my gas bill, I should say, for over the winter time. And then the surprise of Northfield Estates not accepting, refusing April's rent. I never got, I guess I get answers. I guess anything to do with the management, it's like answering a question with a question. And it's just like, change the subject to just keep me confused is all. That's my best defense I have with my management. And the just fix this, fix that, like I'm just a, bleeding deacon of money. And I'm just trying to balance out, that they say things, they like my first initial leak was a back bathtub leak, and the water got in, and around to my back porch enough to surge the porch up, so my porch is pushed up in the back, and that with the winter freeze, and so just that's just all of a sudden that just crushed that, and it's like, gee, I know I have some ideas to fix it, and and then it just. I just don't, I just stay eternally confused. I don't know how to, my best defense is confused. I'm seeking lawyers. I guess I would just get real frustrated with getting callbacks and any direction to go, fixing my, I guess the, latest one.
But they're alleging, they're trying to terminate your tenancy. What's your defense to them terminating your tenancy?
I guess what's I guess so just what's my response to that? I guess fix my front door. My front storm door was their latest thing that they put to be a diligent thing to fix. And they're saying that when it was still frozen in the ground because the hinge broke off. And I'm gonna fix that, and then what's fix my skirting and
have you got all of that? You don't have it all fixed.
I don't have it all fixed. I'm plenty busy with trying to find my balance of money, and my older brother, last of my family to be on this side of the grass that has been kind of troubling me, and I guess just communication with the management it's just answer a specific question or ask a specific question and it gets switched to something else, and and it gets so frustrating. It just helps encourage ADD or something. I don't know. That's my nicest way to put it, I guess.
Your Honor,
So
if I may.
Sir, yes, go ahead. Ms. Fenton.
Thank you, Your Honor. So this is a termination for just cause based on failure to maintain the appearance and yard upkeep. I have received updated photos from my client as of 2 days ago. The home and site are still not up to community standards by any means. I do show that Mr. Ryman painted his home. It's still not up to standard. The skirting's not fixed. There's a ton of trash on the site. There's a ton of trash on the deck. The deck still needs to be redone. There's a lot of condition issues that are still existing as of today.
Well,
And you're not disputing that, you're just
no,
saying.
I'm just, first of all, I guess the paint was painted when my wife was still alive, that, she passed away early 2022. And and we went through the process, a park approved color, and painted that. And then, I had some
But
T111.
sir, you're admitting that the skirting isn't up. There's
the skirting
issues with the deck. I think you mentioned something.
Yeah, skirting in the back was not really visible. It's
well, but
and
you still have to paint it.
Yeah, I'm
All right, look, sir,
I guess excuse me, Your Honor, I guess the park approved color for my paint, I guess I just want to add in, like the modern day, I guess I'm surrounded by aluminum siding mobile homes, and I have T1, wooden siding one, and the park approved color thing. It's like, gee, no, we went through the process to be approved the color to paint it, and so it's just changed the rules. Gets to be just difficult. I don't know. Move the goalpost. I said it right to Jeannie's face, the manager. Change the goalpost, makes it a little change the goal line. It just keeps me in everlasting confusion. I don't know.
All right. So here's the deal. I don't see anything I can try. You've admitted that you haven't kept the property up to standards regarding everything, and I'm not even necessarily talking about the paint. I'm talking about there are other conditions on the premises. So I'm going to find that there's no tribal issue for the court regarding that. I'm going to grant a judgment for possession and termination of the tenancy with the writ date of June 6, 2025. What I suggest you do, sir, is, you either have to move or you're going to have to figure out a way to get out there and try to deal with, get done and deal with management.
Deal with management. I guess then she can reverse this?
Well, they can, if they choose to, they can work with you. But I think quite frankly, sir, there are things that you're going to have to do to try to make sure to get that property up to community standards. Thank you. Northville Crossing versus Nicholas Buckland.
Sydney
And Brittany Moore.
Sydney Fentonell for the plaintiff, Your Honor.
Buckland, Moore, no response. You may proceed.
Thank you, Your Honor. I would request a default judgment. There's current rent due of $806.67, court costs of $246, for a total of $1,052.67, and I would request writ to issue in 10 days.
Judgment to the plaintiff. That is by default for possession. Redemption amount in the amount requested with a writ issue in 10 days. Northville Crossing versus Ardell Carson.
Sydney Fentonell for the plaintiff.
Ardell Carson, no response. You may proceed.
Thank you, Your Honor. I am requesting a default judgment. There is current rent due of $2,131.75, court costs of $190, for a total of $2,321.75, and I would request writ to issue in 10 days.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested. Writ to issue 10 days. Northville Crossing versus Faithland. Is it Lefker?
Hi,
What's your name?
Faith Lefker.
All right. More importantly, the little one's name.
Charlotte.
Charlotte?
Yes,
Okay, how old's Charlotte?
she's 2 months.
2 months, okay. All right. And how much do we have owing?
Your Honor, I show that there's rent due of $1,864.20, court costs of $190 for a total of $2,054.20. I do believe Miss Lefker was looking into getting assistance, so I would just inquire with her what the status is of that.
My notes indicate, well, she was gonna pay 750 that day. Did you get?
I
that?
did. I actually have the receipt for the cashier's check as well if needed.
Okay. And then I think she was getting help from her church.
I'm getting assistance from a local parish, and I also submitted my paperwork with MI Works. I'm just waiting on the caseworker to update me on what next is happening.
Okay. So let me, Ms. Fontenot, do you see a $750 payment?
I do not, but Miss Lefker, when did you drop off that payment?
I dropped it off. It was that day. I dropped it off on May 16th.
Okay.
I didn't see it in the portal either.
Yeah, right. And the only reason I'm asking is because the balance hasn't moved.
So the balance does not reflect a $750 payment. My client's the office is closed today, so I could not confirm whether any payment was received today
Got it.
or before this.
Oh, okay. But she has a receipt. You just hold on to that.
Okay.
Okay. You told me you were gonna pay it that day, and
Yes.
if your receipt, it says the 16th, that's it. So that would bring it down.
1329 is what I was under the assumption that was due, which I will have by the 30th.
You'll have that by will you have that by the 30th with the help from the parish, or
Yes, with them. And then if they're paying 600 of it,
who is?
the parish.
The parish is gonna pay 600.
And then
Okay.
if MI Works isn't able to cover the other half of it or any of it, my grandma was actually gonna help me get that. But then I have next month's as well on top of that. I get paid on the 30th, so I will have that.
Okay.
I will have.
Tell you what I'm gonna do, and I'll do this over the objection of plaintiff. I'm gonna adjourn it out a week. Let her give a shot at getting it done. So May 30th, 2025, what time?
2 p.m.
At 2 p.m. Can you get? Now, the parish, how will they be paying? Will they be sending it directly to the landlord, or will be sending it to you to get to the landlord?
I believe they send it to me. I asked, but he wasn't
Sure.
clear on it.
Okay.
So
And then you'll obviously have your paycheck. Can you get that all paid before, say, June on the 30th?
if it has to be a cashier's check, I could definitely try my best. I just have to get to the bank to get the cashier's check and then.
Okay. All right, give that a shot. I'm
Okay.
gonna give you a week to try to get it, because you at least have a plan here.
Yes.
I think that 750 goes in, so her balance is probably around
It's
1,300 or something.
1300-ish. Yeah.
Yeah, and so we'll give you a shot to try to get that paid.
Okay.
Okay? We'll do that for Charlotte. All right, okay. Take care. I help her with the door. You just went, man,
I got it. I'm just.
No, I know, you're pretty adept at that, but could have, okay, no, man, I know, that's not your job, but geez. Scio Farms versus Jesse Steenberg and Brent Steenberg.
Sydney Fontanella for the plaintiff, Your Honor.
Steenberg, nobody's present, you may proceed.
Your Honor, there's rent due of $96.65. Court
Excuse me?
costs $96.65. Court costs
Okay.
$230 for a total of $326.65. I would request a default judgment with writ to issue in 10 days, but I would also understand if you wanted me to put in there no writ without hearing.
No, yeah, that's it. I will grant your judgment by default for possession. Redemption amount is in the amount requested. with a writ to issue in 10 days, no writ without a hearing.
Thank you.
You're welcome. Court does call the case of Spice Tree Apartments versus Cameron Hall.
Sydney Fontanella for the plaintiff, Your Honor.
And Letwana Mitchell.
Your Honor, Ms. Kingsley and opposing counsel Gail Rosen submitted a consent judgment with a vacate date of June 6th today. I'm guessing it probably hasn't made it to you yet.
No, it has not.
That has been
But
signed.
there's a consent judgment coming through.
Yes, there should be.
All right. Was this a student? Yeah.
Yes.
All right. Then I'll indicate there's a consent judgment to follow, and I'll enter it when it comes in.
Thank you.
Thank you. Whitaker Oaks versus Kathleen Short.
Sydney Fontanella for the plaintiff, Your Honor.
And the second defendant of Brian Pollard. Short, Pollard, neither is here. You may proceed.
Your Honor, we've actually had communications with them today. We did agree to a conditional dismissal, and they are going, let me pull up the terms that Miss Dornbush sent over to me. Pursuant to paragraph 3 of the conditional dismissal, the action is converted to a termination of tenancy. Defendants will vacate on or before June 2nd. Defendants will be deemed to have vacated when keys are returned to plaintiff, and any personal property remaining at the time are abandoned and may be disposed of as plaintiff deems fit. Both of these defendants gave our office permission to sign and submit the agreement on their behalf. I'm not sure why they're not here, but that is my intent.
All right. Then I'll indicate that there's a conditional dismissal order to follow, and I'll sign that when it arrives.
Awesome.
Very good. That's it.
Thank you, Your Honor. I don't know that I'll see you again, so I will see you probably this fall.
Okay. All righty. You're taking care of yourself though, right?
Yes, due with baby in a month, so.
Is it a month?
27 days. I'm not counting down the days or anything.
Well, young lady, congratulations to you again. All right. And I hope everything goes well for you and baby.
I appreciate it, Your Honor. Have a good weekend.
You do the same. Take care. Court stands in recess.